the hearing matters in your lordship's list. But on earlier occasions, but on 2 occasions, lordship was pleased on being satisfied with the urgency to fix this particular matter as item number 1 of the daily supplementary list. But then, with regard to plot of slot and salt which has been resumed. But then time was sought for by the state respondent authority. It has gone down in the list as 1088. But
My lord,
I'm deeply obliged.
Lord, upon notice to the respondent, I'm seeking my lord's kind indulgence to mention this writ petition for extension of interim order. My lord, let it be listed under the heading to be mentioned. My lord, that matter.
My lord, on the last order, your lordship was directed to appear the matter after mentioning my lord, and that is your inclusion upon the inclusion of matter. Upon mentioning, your lordship was on the last order directed to enlisted the matter upon mentioning all are already completed. Affidavit of opposition has been filed. Affidavit in reply has been filed.
It's a hearing matter.
Yes.
Hearing matter.
Lordship may permit to mention on motion matter. Agency that petitioner made an application of section 55 National Highways Act for reference and aforesaid application has not been considered till date. Item number 941.
Give the number.
Lordship,
I have annexed the order also.
Give the number.
Lordship,
Restoration, give the number.
My lord, may I be permitted to mention?
Extension of interim order to be mentioned.
My lord, may I be permitted to mention one motion matter for upgradation, my lord?
What is your urgency?
My lord, my land has been acquired, it is being utilized, and I'm left without remedy, my lord.
May I permitted to mention a matter, ma'am? Yes, ma'am. Actually, I want to do the upgradation. My matter is in the monthly list of 654. Actually, ma'am, main matter is that I'm having a business and the land was given to me by the Jila Parishad. But now the National Highway, they are asking that the land is belong to them. But I constructed the business house over there, and if I'm getting the
Give the number, please.
Lordship, may I be permitted to mention one matter, your lordship?
Why? Sixty-two Act. Give the number.
Lordship, may I be permitted to mention one matter? Your lordship,
May I have my kindly to mention item number 917 of the combined list. The agency is this. This is an acquisition proceeding of 2005-6. Lapsed by a flux of time. One wing, the majority wing of the government is saying this has been lapsed. The other wing of the government, including the requiring body, is saying they are still insisting over the matter which they cannot otherwise. The proceeding being of 2005-6. I am not being able to utilize my property because of this divergence of
Give the
opinion.
number, please.
917. I will just try to.
Give the list. Yes.
Yes, ma'am. Great.
Lordship, may I be permitted to mention one matter? Your lordship, this matter was supposed to appear on 8th of June. It's a group 1 hearing matter, your lordship. It's a part-hard matter, like the petitioner has already concluded its arguments. Only the respondent side is remaining.
One hearing.
Group 1 hearing matter, your lordship. Much of.
Group 1 hearing.
Your lordship, may I be permitted to mention a matter? On the previous occasion, your lordship was pleased to observe that this present matter can be disposed of easily by way of directions, and the state was given the direction to come back with instructions. If your lordship can kindly take it up one day and dispose it off.
Give the number.
Yes.
Yes, call the raise this, please. Anyone in item number 1? Non-prosecution solicitor. It was mentioned on behalf of the petitioner that the petitioner does not want to proceed with the matter any further. Today, none appears for the petitioner. Paragraph in view of the submission made on behalf of the petitioner on the earlier date, the writ petition being WPS as and such is dismissed for non-prosecution. There shall, however, be no order as to cause certain certified website copy.
My lord, item number 2, my lord, this is my application for restoration, my lord.
Have you served?
My lord,
Okay.
my lord. And your lordship on the last occasion was inquiring, my lord, the application was filed on 11th March 2020. And the dismissal order is of 11th, dismissed for default on 11th March 2020, and application for restoration was filed on 22nd January 2021.
It's beyond time.
My lord, your lordship knows at that period of time there was staggered functioning of court, and the Honorable Supreme Court have extended, my lord, all the limitation. Your lordship allowed this.
Can we deal with the writ petition now?
My lord, very short matter. My land has been utilized by the authorities. I made a representation for compensation. That ought to be considered, my lord, which is at page. And they have acknowledged my representation. My lord, my representation is at page 29 and their acknowledgement is at page 31. They have sent it to their higher authorities for inquiring and consideration. Additional district magistrate court.
It has been forwarded to the executive engineer. I
My lord,
think.
that has, yes.
And he'll deal with it? Who will deal with it?
My lord, the land has been utilized by PWD
Special land
authorities,
acquisition of-
special land acquisition, because
Can 1 of 2021 restored. WPA. The writ petition, by consent of the parties, the writ petition is taken up for consideration. Paragraph, it is contended on behalf of the petitioners that the land of the petitioners was acquired by the state respondents.
5. My lord, respondent number 5, man. Executive.
And a PWD building has been constructed therein. Stop. No compensation. It was acquired.
My lord, it was utilized, but we have not received any acquisition notice.
We must say that we utilize that land. After that manner, that will be sent to the.
Your lordship kindly sees page 31.
So it has already been forwarded to the executive
Yes, my lord.
engineer. Let him deal with the matter.
Yes, my lord.
That is respondent number 5.
It is contended on behalf of the petitioner that the was utilized for construction of a PWD building. But no compensation has been paid to the petitioners for the same. Stop. The petitioners submitted a representation before the concerned authority in this regard on 12th July 2019, pursuant to which 2019, which was forwarded by the superintending engineer, Southern Highway Circle, PW within brackets, bracket roads, bracket close directorate, to the executive engineer, Diamond Harbor Highway Division, PW within bracket roads, bracket close directorate, by a letter issued on 22nd July 2019. The petitioners pray for consideration of their representation and payment of compensation in their favor. Paragraph, it is submitted on behalf of the respondents that the executive engineer, Diamond Harbor Highways Division, PW within bracket roads, bracket closed directorate, being the fifth respondent herein, be directed to consider the representation in accordance with law. Paragraph, in view of the above, this court is inclined to hold that since the representation submitted by the petitioner has been forwarded to the fifth respondent for consideration, comma, the said respondent is directed to consider and dispose of the same within 1 month? Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Disposed of, which are
Grateful.
next.
Item number 3.
My lord, in this matter, I beg to appear for the
In
petitioner.
item number 3, my lord, Mr. Sengupta is appearing, my lord. My lord, last time lordship dismissed the review application dismissed for default, my lord. Review the review application. We have already filed a restoration application, my lord. If your lordships, my lord, kindly adjourn this matter for 1 week, then review application was dismissed for default, my lord.
A show cause has been issued to the upon the alleged contemner in the contempt application. What
Yes.
about that?
Yes, madam.
So cause
Yes.
already issued.
Where is the show
Oh,
cause?
my lord, Mr. Sengupta is, my lord, in this appearing in this matter, my lord, kindly.
Not
take it up.
today. Show cause should come tomorrow, or otherwise rule will be issued.
Grateful, lordship.
Not today. Even if you filed a review application, the show cause application should be filed tomorrow.
Yes.
Item number 4.
My lord, I am appearing for the petition.
My lord, in this matter, also Mr. Sengupta appearing, my lord, but my lord, in this matter, my lord, the authority as per lordship's direction, my lord, the authority, my lord, assess a compensation amount, my lord, but they are not agreed to, my lord, to accept this amount. And that's why, my lord,
My lord, in earlier occasion, your lordship adjourned the matter for issued a
my lord,
notice.
kindly take
My
it
lord,
on, they
on
have already
2nd May 2023, my lord, regarding the submission of some documents before the authority concerned. I submitted the document, and my lord, till date nothing has been paid. My lord, that petitioner is suffering. Your lordship kindly see, your lordship in earlier occasion implement the joint secretary as party, and specific direction has
It's
been
allowed as a
given.
last chance. Let
to-
it was already allowed as a last chance.
Yes,
So
my
today
lord,
I
in
will not
5
allow
times.
any accommodation.
Times.
Let rule be issued. Let your
Yes, my lord.
contemner come before the
my lord,
Not
kindly,
kindly.
keep it on tomorrow, my lord.
Kindly.
Yeah, with this
Let him
matter.
spend some time in jail. He'll know what a court
No, my lord,
order
kindly
is.
keep it tomorrow, my lord, keep it tomorrow.
5 times last
Sir,
chance.
they
has
have
been
already-
given,
I
my
make
lord, no
it very
comments.
clear that no adjournment will be granted.
My lord,
Not today, come
kindly
back
they
tomorrow.
have
Ask your contemner to be ready. Next,
Grateful, my lord.
not today.
Item number 5.
Item number 5, my lord, I appear for the petitioner, my lord. একটু ধারণা ঘটবে।
Mr. Dey, your appeal?
Yes, ma'am. My lord, that matter, my lord, where, my lord, I am always, my lord, taking time for this reason.
Direct
My lord, that is
purchase.
yes, my lord. And now, my lord, previously, my lord, I request the DM to issue notice, my lord. Now, the issued notice to the additional chief secretary, finance department, my lord. And not the late stage, my lord. So, my lord, I pray only another time, my lord. For the hey, you know. Only thing, my lord, I want to submit, my lord, according to the scheme, my lord, the DM has to fix the price, my lord. My lord, according to me, my lord, from the going through the papers, I could not find, my lord, DM in a meeting convened, whether he has convened the meeting and fixed the price, my lord.
How much more time do you require, Mr. Dey?
Yes, my lord.
How much time do you require for the entire?
Only 1 month, my lord. If that is no, my lord, your lordship can issue rule. 1 month time, my lord. I pray, my lord, every day, my lord, I pray. My lord, I pray time before your lordship.
As a last
behalf of-
chance, rule will be
Yes.
issued on the next day.
Yes, my lord.
As a last chance.
Let it go down in the order, my lord. Yes, my lord. If that is which rule we.
I'll allow it as a last chance.
Yes, my lord.
Uh,
My lord, it is a very vigorous condition, my lord, that
I am
Copy
always
of
taking time.
a letter issued by the Additional District Magistrate within bracket land acquisition bracket close Nodia to the Joint Secretary Government of West Bengal, comma, Irrigation and Waterways Department on 8th June 2023, comma, submitted on behalf of the alleged contemner is taken on record. Paragraph. Learned counsel for the alleged contemner seeks a month's time to comply with the order under contempt in its entirety. Paragraph. As a last chance, the prayer is allowed. Paragraph. It is made clear that rule of contempt shall be issued against the alleged contemner on the adjourned date in the event the order under contempt is not complied with. Paragraph. Let the matter appear under the same heading on 20th July. I give you a little more time. 20. Next.
Item number 6.
I am for the petitioner, Your
Lord,
Lordship.
I appear for the alleged contempt. May I file my affidavit of compliance, my lord.
Petition, the applicant petitioner, you are appearing.
I am happy.
Have you
Good.
received a copy?
No,
But I am
just
having-
receive Your Lordship.
You want to go through this and come back?
Yes, Lordship.
Yes?
I'm good.
Affidavit
Okay,
of
just go to-
compliance
I took-
submitted on behalf of
on the-
the alleged contemner.
Huh?
Number
Come on,
2
come on.
is taken on record. Copy of the affidavit
Sure.
is
Aquí আছে।
made over to learned counsel for the applicant petitioner in court this day. Paragraph. On prayer of the applicant petitioner, the matter is adjourned. Let the matter appear under the same heading on 10th July.
Thank you. I'm extremely good.
Item number 7.
My lord, in this matter, I am appearing for the petitioner. On the last occasion, I prayed for a week's time to obtain instruction in this matter from my client. But my lord, no instruction is forthcoming. My lord may dismiss it for default if my lord so.
So I cannot record your
No, my lord,
appearance in that
kindly
case.
do not record my appearance.
None appears for the petitioner. Petitioners, no accommodation is sought, dismiss for default.
Register.
So item number 8.
My lord, I appear for the KMD.
Petitioner, you are appearing? Yes. You are asking for some time? You are asking for an accommodation? Let him come back. He's not well.
On help ground, we cannot stand in the way.
On prayer of the petitioners, the matter is adjourned. Let the matter appear under the same heading on 12th July. 12th July.
এই পারবে শরীর ঠিক আছে
Item number 9.
My lord, in this matter, Mr. Shishuna Bandhavadaya and Onkokumar Nak appearing in behalf of state.
Who is appearing for the petitioner? Mr. Roy for the petitioner. Where is he?
My lord, I've also instruction.
Yes.
I've also the instruction from the concerned department.
You want to file the instructions?
My lord, if you allow, may I file?
Anyone for the petitioner? Dismiss for default. Yes. This is the instructions.
Instruction from the concerned department.
Written instructions submitted on behalf of the state respondents is taken on record.
Well,
Paragraph. None appears for the petitioner. No accommodation is sought. Dismiss for default.
obliged.
Item number 10,
Lord, by order dated 31st March, your lordship has called for a second report from the ADMLR. But today, my lord, I have some personal difficulty. May I pray for an adjournment for 7 days? Lord, I have the report with me. I'll place it after 7 days.
Petitioner, you are appearing?
Inspection has been done.
Inspection matter was not today. It did not appear.
So today I'm ready with the instruction.
Personal difficulty, I won't stand in the way.
Let him come, let him come.
Um,
Learned counsel for the state respondents seeks extension of time to submit the report in the form of affidavit as called for. Paragraph, let the matter appear under the same heading on 12th July.
Form of affidavit.
This month it will not be possible. Come back on.
Inspection has been done. Now the report.
item number 11,
11 my lamp for the petitioner. May I file the exception to the?
Yes, yes. Have you served?
Yes, yes.
আমাদের opposition. We have also opposition. Opposition is also fine. Representation consider করবে বলে দাও না। There is an issue with the lordship gets in the paper.
Yes.
There,
yes, your
there
question.
is petitioner's land was acquired, initially utilized by the coal, respondent coal company for the purpose of mining purpose. Subsequently, then at that point of time, they didn't acquire initially my predecessor was the owner of that plot of land. When the land was acquired, there was a scheme for employment under the land losers category. I was advised to obtain the land in my name, and then transfer the same in favor of the coal company. The person to their advice in the year 2008, I executed a deed transferring the land in favor of the coal company. While execution of that deed, no consideration was, though there was settled a consideration price, but in terms of since and offer was, there was a talk give employment, no consideration was paid to paid. Right, even in the deed, that was mentioned. Initially, my name was recommended for employment purpose. Time to time, no employment given. I approached this honorable court in 2014. My Lord Justice Banerjee, Sanjeev Banerjee directed the authorities to take. Let me finish, my Lord. To take a decision. While taking decision, they have raised some point. At that point of time, since I acquired, they took the point. I acquired the title of the plot. After use the land. When the land was used, that at that point of time, some portion was in the name of my father, and some portion in the name of another person. Since they refused to offer my the service, employment, that order I challenged before this honorable court. Again, second time I challenged that rejection order has been challenged. While that writ application was moved, that writ application was dismissed with a finding that it's a disputed question. This is not the appropriate forum. An appeal was preferred. Appeal court also dismissed the application, considering that in terms of scheme, there is when the scheme there is no scope for since my land fall under 2 zone of the respondent coal company. That's why that cannot be considered. Then my lord, my compensation part remains. I approached the authorities. Since I have not received any compensation, then my lord, I have not received any compensation. Even my predecessor of interest or not received any compensation. My lord, no employment has been offered. Then my lord, I approached the authorities to pay adequate compensation. That was not considered. Then, my lord, this writ application has been filed. While, my lord, the writ application was filed, my lord, it took time, my lord, the file.
Millard, I have checked up, Millard, if he permits me to say. Millard, the land was acquired, Millard, prior to him, Millard, becoming the owner of the property, because coal extraction and removal of overburden started in 1993. Now, Millard, Millard, thereafter, we purchased it from him. He took it from someone else was the owner. Then he became the owner in 2008. We purchased it from him. But the coal company is in possession and extractions on 1993. Millard, initially he said, Millard, he doesn't want money, he wants employment. That was fought out in this court, disputed question, because there are cross claimants, Millard. The scheme did not provide for it. So, Millard, it went up to division bench. Now, today the question is, Millard, there is a deed executed by my learned friend's client, Millard, in favor of Millard Coal India. Millard, there is a deed valuation is given. He has filed a representation. Naturally, Millard, if the extraction has started, Millard, prior to the deed, he also may have some claim, the predecessor, Millard. The predecessor, because the extraction, he has permitted me in his query.
You are the predecessor also along with the petitioner in
Yes,
disposing of the
yes,
representation?
I suggested.
Millard,
Millard,
what happened in my last?
I am saying so.
Indemnity.
হবে না, এখানে তো affidavit হয়ে গেলে তো আরো problem হবে না। Millard, the predecessor has to file an indemnity that I'll not be further, Millard, saddled. And Millard, I'll dispose of the representation in whatever form, Millard. Giving Millard my opinion, Millard, within Millard 3 weeks time, Millard. Because ultimately, Millard, there's a RTI. RTI says, Millard,
No
amount
payment has been made.
I'm saying so, sir. Amount has not been paid. There's a RTI to the effect by my officer.
That is not in dispute.
Yes, no, Millard, now who is entitled to the payment? Because the possession has been taken in either Millard, the predecessor may have a claim. So, Millard, I will consider the representation with the shortest possible time, Millard. There's a RTI report, Millard, that he has
I have
annexed.
annexed,
He has annexed. I am saying so, Millard.
I have annexed one. Can you have a look, my lord, the page?
Yes, what do you suggest?
Because
Is
affidavit
the
3,
proposal acceptable to you?
If one of they consider my representation for payment of
affidavits
consideration.
will not
Well,
pay bill.
Yes?
Affidavits will take the matter in
No,
the
he's
bottom
not
of.
asking for affidavits.
No, that's the reason I suggested.
already by way of report, they have already filed an affidavit.
I have not dealt with any of this, the writ petition, and Millard, the predecessor should be a party. I'm not on that,
No,
because if affidavit, the matter, Millard, will get stuck, Millard. I'll consider this representation with the
He's
shortest
given
possible of time.
opportunity Hearing to the predecessor
Yes.
also,
Yes,
so that
If they want to survive, my lord, they
Yes,
have
yes.
already,
notice will be sent.
I'll
they
send
have,
a
they have
notice.
already transferred, their entire right, by way.
Utilization was prior to transfer.
Yes.
Yes,
Admitted.
but
Admitted.
even then,
So they may have some claim.
yes,
Let
if
it be heard.
if
There is no difficulty.
along
they
with
at all traceable, these things, it was in the year 1993.
Let the company serve a notice to
I'll
them.
serve a notice. and give a-
Then they will
If
say,
they do not
they
appear-
not.
If they do not appear, it will be heard.
Yes,
That will be
yes,
heard.
all right, all right.
In their absence, Lordship will provide.
There will be some endorsement in the notice to that effect.
Yes,
Me, they will.
Yes, if you are agreeing to this, then I'll pass an order to them.
yes, yes, all right.
Affidavit will not serve the purpose, Millard. Lordship, unnecessary,
You
Millard.
need
1 hour.
compensation.
Yes, yes, my lord.
That should be considered.
Sale
Yes,
deed,
That's
sale
the
deed.
crux.
You are the
Admittedly,
what's
they
the
have
value of the sale deed.
Yes,
Valuation of the
yes,
sale
the
deed
sale deeds.
hasn't been paid.
He said
It's in
yes,
kept in,
without any consideration.
yes,
He's
without,
asking for that.
that's in
Yes.
the RTI report, Millard, that is kept in, Millard, the fund of ECL, Millard, separately.
Affidavit in exception
Great.
used by the petitioner to the report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph, heard learned counsels for the parties. Paragraph, it is contended on behalf of the petitioner that the respondent company has been utilizing the land in question since the time of the predecessor in interest of the, you have purchased the property from your
Yes, yes,
predecessor.
some portion purchased, some portion
Since
gifted.
the time of the erstwhile owner. Plus two. Since of the erstwhile owner. Stop. The petitioner subsequently purchased the said land from the erstwhile owner.
But I have transferred, my lord. They have not transferred. I have transferred them.
You
correct.
purchased from the erstwhile owner,
Yes,
then you
Then
transferred.
transferred to ECL by
And,
two
yes,
thousand.
and transferred the same in favor of the respondent company by virtue of a deed of sale,
Yes, yes.
deed of sale executed on
Executed on in December, my lord, 2008, my lord. Just a minute, my lord.
is it 8th January 2008?
Yes, yes,
8
yes.
January 2008.
On
That's
8th
annex.
January 2008. Stop. The petitioner did
There is a
not receive,
settlement, there is a fixation of price, my lord, 4,442.
did not receive the consideration stated in the said deed
But
on an assurance of being given employment as a land loser. Stop.
4,40,000.
Since
Ah.
such employment was denied by the company, comma, a writ petition, the petitioner approached this court in a writ petition being WPA
56391.
19902, a WP 19902 within bracket W of 2014. Stop. By an order passed on 4th March 2015, comma, this court, a coordinate bench of this court, directed the concerned authority to consider the petitioner's case for appointment and ensure that the petitioner is given appointment if he fulfills the eligibility criteria within 3 months from the date of receipt of the order. Stop. In the event the petitioner was found to be ineligible for the job on any ground whatsoever, comma, due reasons in support of such decision, due reasons in support of such decision would be communicated to the petitioner within a fortnight of receipt of the order. Stop.
বলে দিচ্ছি।
Yes.
There's a subsequent order by Justice Banerjee, page
My lord,
59.
18th April 2015, my lord, thereafter, my lord, order passed, my lord, page 51, my lord. Pursuant to that order, my lord. Page 51.
Page 51 টাই উনি পড়লেন।
No.
Pursuant to the said order, the respondent company dealt with the request of the petitioner and upon consideration of the entire facts, comma,
Where observed, my lord, I am entitled to get my compensation.
Turned
First
down.
paragraph of second.
turned down the request since
Page 52, my lord. First paragraph.
Page 52
since
bottom.
it was dehors the prevailing norms of the company.
Great. This was again,
My lord, in that my lord, order, my lord, he has observed, my lord, I am entitled to, my lord, the
that order
land
was,
value, my lord.
that
And the
order was again challenged, page 59.
first paragraph, my lord, of that page, my lord, 52, page 52.
The said order was
They will get the value of the land, my lord. It's the order of,
assailed. No, that is there.
yes, my lord.
Assailed before this court in a writ petition being number 17527
59.
within bracket W of 2015 and by an order passed on 11th August 2015, comma, this court
Page 60, Miller.
turned down the prayer of the petitioner with liberty to the petitioner to approach the appropriate forum for redressal of his grievance. This order was carried in appeal.
This
Yes,
was in
yes,
appeal,
yes.
Miller. This was in appeal. The appeal court order,
This
Miller,
order was
64. Page
Carried in
64.
appeal by the petitioner and an honorable division bench of this court, comma, by an order passed on 15th January 2020 in
64 at 65.
FMA 3715 of 2015, upheld the order of the Honorable Single Judge. The petitioner submitted a representation before the concerned authority on 7th March 2022, claiming payment of adequate compensation as per rehabilitation and resettlement policy of the company, a policy of Coal India Limited, 2012. Stop. The said representation is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents. Who should consider?
Millard, it will be considered, Millard.
The
By the
director,
general manager, Millard. General manager, page 67, serial number 2, he will consider.
fifth respondent? Fifth respondent?
Fifth respondent, he will consider.
That the fifth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the fifth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 weeks.
3 weeks I'll do.
Within 3 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of?
কিছু বলিস না। Great. Much open.
Next.
Number 12.
I've got the petition, Your Lordship.
I am appealing for the respondent number 4, my lord.
On the last occasion, there was a direction upon the state and the Jilla Parishad to file a report in the form of an affidavit, Your Lordship.
Who is appearing for the Union of India?
Last day, Mr. Gautam Sarkar and Gautam Malik has appeared.
Yes.
No comment.
You are appearing for the Jilla Parishad?
Yes, my lord, I am appealing for the Jilla Parishad, my lord. In shortcut, my lord. Matter is
You
relating
have to
the-
submit a report in the form of an
Yes, my
affidavit.
lord, my
What is
lord.
the
My lord,
report?
difficulty is this, my lord. My lord, may I express, my lord, myself? My lord, actually, my lord, it is the policy of the state. My lord, throughout the West Bengal, my lord, your lordship knows, my lord, as per act, my lord, state acquires the land, my lord. My lord, Jilla Parishad is a instrument of state. So, my lord, so far acquisition or requisition of land is concerned, my lord, Jilla Parishad has practically no role in the matter, my lord. My lord, we are practically instrument of the state, my lord. What state directs, we follow that, my lord. So, my lord, if
A
your
report
lordship,
was also called for from the state. Yes,
Lord, I will file report, your lordship kindly extend some time. Lord.
you are not ready with the report today?
Yes, Lord, I have sought for instruction, but I am not satisfied.
You are aware of the prime issue.
Lordship. I have sought for further clarification.
Let them come back.
and my lord also directs the Union of India to communicate the order, my lord.
Yes, yes. The Union of India, the last occasion, someone has appeared. Your Lordship, on the next date, I will communicate the Union of India to appear.
I
What role
think
does the
their
Union of
presence
India
is-
have to play?
Your Lordship, the 2013 Act is an Union Act. The basic question over here is, Your Lordship, the state is not following that. They have a policy of 2016. 2013 Act clarifies, if any of the state wants to give a better benefit to the land loser, they have to form an act. That cannot be done through the policy. So the Union of India, the 2013 Act is in 2013 it is implemented for land. 1st January 2014 is the cutoff date from when this Land Acquisition Act has come into force. But we are in 2023, nothing has been done. So the union has to express what the opinion is regarding this. Can a state follow their own policy?
So please inform them about the adjourned
My
date.
lord, one thing, my lord, it must, my lord, kindly look at this, my lord, his prayer, my lord, one gazette notification. It amounts to act, my lord, which state is following. It is his submission, my lord, I am doing with his permission. State is, my lord, gazette notification is not challenge practically. So, my lord, I think notice must be served upon the Advocate General also. My lord, they have challenged practically the virus of the act also.
So, my lord, they should.
It's a policy, not a.
If the virus of the act is challenged, my lord, they should give notice.
Where is the act to be challenged? Where is the act whose virus is challenged?
It
There
is,
is no act at all.
is a notification, my lord,
It's a
subject to
policy.
kind correction. It is a policy, my lord.
Policy is not an act.
It's no, my lord, but it is a gazette notification. It's equivalent to act, my lord, subject to kind correction of your lordship. So, my lord, I think,
Let
my
the
lord,
state
this is my
come back with
respectful
the report, let us
Yes,
see.
my lord, it's state submission.
Because
my
the
lord,
petitioner submits
Definitely, he will
that
submit
the
the
land
next
is purchased and compensation is paid according to the 2013 Act, he has no difficulty.
No grievance.
He is agreeing to it.
My lord,
So this proposal was to be considered by you.
by the state.
My lord,
By
only
the state.
instruction which I got, my lord, that is that the agreement of the land purchase was made between the landowners and district level officials. That is under the consideration of the state government. That is the
The
only.
petitioner doesn't agree to that.
Yes.
The petitioner says he'll part with his land only if you pay compensation according to the 2013 Act.
Yes, my
You
lord,
were
that's,
asked to take instructions on that issue.
my lord, that's true, my lord. But, my lord, if it is the instruction of state, then, my lord, matter is premature. Because, my lord, I am just submitting, my lord, because he says, Mr. Moitro says, his prayer is under active consideration of the state. So, my lord, in the meantime, my lord, he has filed the writ application. My lord, I don't know
Let the report
what is
come.
what.
Let the report
My
come. Let
lord,
us
my
see
lord.
what
For
comes
this
before
reason,
us.
report is
Yes,
required. My
yes.
lord. I'm
And
deeply
you do
obliged,
not
my lord.
intend to submit any report.
No, my lord, I will not, my lord. I will just adopt his.
Learned counsel for the Jila Parishad submits that no separate report is necessary to be submitted by the Jila Parishad.
Because, my lord, it's the
Since-
policy of the.
Since the Jila Parishad is only an instrument of the state, and the report of the state shall suffice in this matter. Paragraph, learned counsel for the state respondents seeks extension of time to submit the report in the form of affidavit as called for. Paragraph, let the matter appear under the same heading on 13th July. Please be ready.
Grateful. My lord, it will appear on
13th July.
13th July. I'm deeply obliged. I'm grateful.
13 and 23, my lord, the advocate on record father had bypass surgery, my lord.
13 and 14.
13 and 23, my lord.
23.
Yes, sir, 13 and 23. Was not found. And 24 not received.
Let us deal with 13 now. Who is appearing for the respondents? Respondents? No one.
And on the 23.
Let it be adjourned for some time. In 13, no one for the respondents. Mr. Rajoshi Basu. None appears for the respondents. On prayer of the petitioners, the matter is adjourned. Let the matter appear under the same heading on 13th July.
13th July.
23 তে খালি adjournment record করে রাখুন 23 since Mr. Day is appearing, let it be on the same date.
13th.
On prayer of Mr. Day as for the statement. On prayer of the petitioners, the matter is adjourned. Let the matter appear on the same heading on 13th. Yes, next.
At number 14, let I appear for the KMD. I have filed my report pursuant to your lordship's direction, but no exception I have received. With
My lord,
my learned friend,
I am for the petitioner.
Yes.
Every reply against the report is ready, but there is no Xerox copy. I have to.
You want to use an exception?
Yes. My lord, from their report, it admits our case. Our case is that the property has not been acquisition from
So
our.
why do you want to come up with an exception then?
My lord, I have to serve copy. One copy is ready, final copy.
If the KMDA has admitted your case, why do you want to come back with an exception?
Because I have made some denial. Our case is the property is not acquisition and no compensation money was paid. From their report, it is admitted the property was purchased, was the owner of 3 persons. One Rajanikanta Mondal, Bholanath Mondal and Pachu Mondal. They stated
that they have, they made ready for payment in case the Bholanath Mondal and Pachu Mondal. I am Rajanikanta Mondal. My lord,
If it is acceptable by,
my lord,
my lord may consider our report.
You want to come back some other day?
that will be
Give the
better.
exception?
That will be better because I have extra copy. My lord, fix a date.
Entire picture.
No. The
Stated in
entire
our
proceeding has been lapsed in another case
Learned counsel. for the
regarding that
petitioner
land.
seeks extension of time to use an exception to the report in the form of affidavit submitted on behalf of the KMDA. Paragraph none appears for the
State's presence is necessary. State, where is the state?
Mr. Ghosh is appearing for the KMC.
KSB is not a
KMC
party.
is not a
KMC
party in the
Wrongly,
cross-site.
wrongly served copy to him. He told
My
me
learned
that
friend has made a mess. Another writ petition filed in
wrong-
group five
copy was wrongly served.
determination.
So who is appearing for the state?
State's presence is necessary, acquisition by state.
Yeah, this one number 6 was KMC in a party. meeting.
KMC is not party.
কেএমসি কে এটাতে করোনি তো
না
কপি দিয়েছো তো
Have you served the state?
yes, my lord.
unless state counts. Mr. Shishano Bandyopadhyay is appearing for the state. In this matter, I find from earlier order recorded.
The কারিগরটা দেখো।
Yes. And Orko Nag, they were appearing.
Yes,
So today I do not find them.
today they know.
Or
Let a
6
notice be
extension
given.
time, right? Above
Let-
paragraph, none appears for the state respondents. Paragraph, let the matter appear under the same heading. On 11 July.
Let
Paragraph,
my learned friend intimate the state.
yes, paragraph, the petitioner is directed to serve notice upon the state respondents intimating the adjourned date.
Yes.
আরে কপি নেই আর কপি দিয়ে দিলে কি করে জেরক্স
11 to 9.
Appearing on behalf of the petitioner, my lord. Here, my lord, I led by Mr. Milan. Senior advocate is not come, my lord, kindly.
You're asking for time? You're for the petitioner?
I am for the petitioner, madam.
Only 15.
I am for the state.
15?
15 contract.
Like,
I am for the state.
fine.
আপনি আপনি কোনটা? হ্যাঁ আপনি কোনটা?
Yes. Who is appearing for the
I am for the
petitioner?
petitioner. I am for the
So he is not appearing.
I have served upon all the respondents, my lord, service is effected.
Private respondent?
Service is effected, last time, my lord. The affidavit service.
My lord, first time, please see the cost item.
The cause title?
Yes, madam.
Yes.
No, no,
First page, page number 1.
that is independently way.
Yes.
No, my lord, that is not. The Group 1 matter, my lord, land matter. Liberty may be granted to me, my lord, to correction of the same. My lord, the petitioner is the owner of a particular 2 plots of land, wherein the private respondent, my lord, that plot was annexed, my lord, annexed P2, page 45, my lord. Page 45, my lord. The plot number 1282 with a total area of 35 decimal.
Cause title says group 1.
Group 1, my lord, but it is mentioned in the West Bengal Land Reforms Act, that is not
Yes.
in the classification list. Group 1 matter, my lord, but wrongly it was mentioned as West Bengal Land Reforms Act. That was not correct, my lord.
Wrongly mentioned
My
as?
lord, my lord. Leave may be granted to correct here now, my lord.
The presentation form.
My lord. As well as the first item.
In the cause title, it's group 1.
Group one matter.
So this is group one matter.
Group one matter. Land
So this
matter.
is correct.
My lord.
West Bengal Land Reforms Act.
No, that is not applicable. That is not applicable. My lord, kindly come to page 45, my lord. The record
So
of
this
the.
is not under the Land Reforms
No,
Act?
no, not at all, my lord. Not at all.
What is your prayer?
My lord, my prayer is that already as per considering the representation of the petitioner, DM initiated a proceeding. My lord, kindly come to page 7, annexure P7, page 75, last annexure, my lord. And directed the concerned authority to take necessary action at the earliest, considering the considering the representation of the petitioner and action taken report and assigned positively. That proceeding was not concluded, my lord. That may be concluded by the said authority, my lord.
But I think this is under the Land Reforms Act.
No, no, not at all, my lord. The issue is this, my lord, the private respondent herein, my lord.
Restored the nature and character of the case, or Mr. Dev,
No,
prayer
my
B.
lord.
Yes, my lord. I have
No.
seen, my lord, only,
No, my lord, not at all. The private respondent herein forcefully excavated the earth of the petitioner and converted the land of the petitioner with the help of the local hooligans. my
That
lord.
is illegal conversion.
Actually, not position of the taken over position of the land, my lord.
This is illegal conversion.
My lord, conversion is not at all. Conversion may be
You
made,
are
my lord,
asking for restoration of nature and character of the land.
of not only that, my lord, to back over the position to my.
This is not acquisition.
No, not at all acquisition. Not at all acquisition. No, no, not at
So
all.
it cannot be under group one.
Private, my lord, I have a judgment, my lord, in this helpsome point. In the
Please show
helpsome
me.
point, my lord.
Please show me.
No, my lord, no, no, actually, my lord, kindly again 1 day's time, my lord. 1 day Jacobitis, in the helpsome cause of action, my lord. In the one of the honorable bench of this honorable court, my lord. In the helpsome cause of action.
Prima facie, it appears that this could, you have stated illegal and another prayer D.
My lord. My
Illegal and
partner is-
unauthorized conversion.
the already DM has initiated a proceeding. my
Maybe, but that will be under the Land Reforms Act.
lord. That may be decided by the, concluded by the concert DM. my lord.
Cannot be, cannot be.
My lord, then on the accommodation. can be given.
They are A, my lord, also.
No,
That is
All the prayers ask
all
for
the prayers are done.
restoration, yes.
So, my lord.
question
And
of land
the
use of does not have.
immediate steps thereby close down the illegal fishery with an immediate effect and to restore the entire.
Yes,
of
no.
the original form.
I shall,
Or that is
I shall
my
cover
lord,
by
I
a
said
judgment,
in
my
the
lord.
West Bengal Land Reforms Act, the petition
No,
is not.
no, I shall cover by a
You want to
judgment.
come back?
One day
He
accommodation.
wants to come back, let him come.
Yes, my lord.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 27th June.
Get full, my lord. My lord, affidavit service.
Affidavit of service. Online. Twenty-seventh June. 27.
And number 16.
My lord, 1617, Lordship, I beg to excuse, Lordship. I could not make ready the exception against the report filed by the Eastern Coalfield Limited, Lordship, due to serious illness of my younger sister, Lordship.
So you want to come back after some time?
After some time, Lordship. I am praying for 2 weeks' time, Lordship.
Learned counsel for the petitioner seeks extension of time to use the exception to the report in the form of affidavit submitted on behalf of the respondents. Paragraph, let the matter appear under the same heading on 12th July.
Lordship, I am for the Eastern Coalfield Limited,
Yes, yes.
led by Mr. Shivshankar Banerjee. Both
12th July.
Lordship, if it is possible, Lordship, 27th June or after.
There are too
27th
many matters, madam. I'm sorry. There are too many matters.
12th
Come back on
July.
12th July. Yes. Please serve an advance copy so that we can deal with it.
Lordship,
Number 18.
Seventeen.
18.
Yes.
Lordship, Mr. Kajal Roy is appearing on behalf of the petitioner. Due to illness, he could not come to court, Lordship. I am praying for not today.
Service completed.
No, sir.
Private respondent.
No, Lordship.
Mr. Dey, you are appearing in this matter. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 13th July.
Lordship.
And number 19.
19, my lord, I am for the petitioner. He is my
Yes.
senior, my lord.
Mr. Milan Bhattacharya Mr. appeared in.
You are in this matter.
Yes, madam.
Who is appearing for the respondents?
Yes, Mr. Dey.
Mr. Day is appearing. You have taken adjournments on several occasions. So
Last
please be,
occasion, my lord, the matter was hard. Last occasion, matter was hard. And
So-
time is so much limited.
That is the file and
The
application.
issue, my lord, that pending is the issue is pending before the Supreme Court, my lord. That,
Whatever to be that.
my lord, Supreme Court is pending, my lord. That's
but this
that,
is under
my
the
lord,
West Bengal
regarding, my
Land
lord,
Reforms
issue
Act.
here, my lord, I'm not asking, my lord, any relief from 14T3. I am asking, my lord, if I member of the Bhumijivi Sangha member, then my lord, I'm entitled to give some relief. So,
Your prayer is not to give any effect
Effect.
of vesting.
yes,
This is purely under the Land Reforms Act.
my
This
lord,
court will not have
my
jurisdiction.
lord, kindly see the, my lord,
Why don't you go before
lord,
the appropriate forum without
yes.
wasting further time?
My lord,
If
my
you
lord,
take
kindly
a
see
date,
the,
you will only
kindly
waste
see
further
this,
time.
order, my lord, Supreme Court order, my lord, kindly see. Only by Bhumijivi Sangha member, my lord, can.
Maybe, but this court doesn't have jurisdiction.
Well, only, my lord, because, my lord, I am here, my lord, division bench, I am made a party.
Maybe, but this court doesn't have jurisdiction, sir,
My
under the
lord,
Land
then, my lord,
Reforms Act.
refer the matter division bench, the matter is pending.
Can this court refer a matter to the division bench? I can
Matter-
give you liberty to approach the appropriate forum. That's all. Will you do that without wasting further time? If you take a date, it can be granted, but you waste more time, isn't it? Go before the appropriate forum for redressal.
My lord, my liberty to division bench so that I can, my matter is pending before
I
the
will
division.
only state appropriate forum. I
Yes.
cannot refer the matter to the division bench. Yes? The matter pertains to the West Bengal Land Reforms Act 1955. Paragraph, learned counsel for the petitioner seeks to withdraw the writ petition and approach the appropriate forum for redressal of the grievance of the petitioner. Paragraph, in view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. Liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, there shall be no order as to costs, urgent certified website copy.
Number 20. My lord, I appear for the KMD.
For the petitioner led by Mr. Ranajit Chatterjee, madam. Earlier, on several allegations, the matter was taken up for consideration. Since the service upon the private respondent was not affected.
Have you served?
Yes, Malat. Lastly, Malat, we made a paper publication as per lawsuit. This is the last affidavit. Malat. This is the earlier two
None of the
affidavits.
private respondents could be served.
No, Malat, two private, who is the actual owner? He received, thereafter who was sublet, he received. No, actual owner was not received, was subletted, Malat, he was not received, but presently who is running the business, the gym, they have received.
There is no actual owner. Owner is the KMD.
Yes, owner is the KMDA, lease deed was allotted to the concerned person. My grievance against the concerned person violating the lease deed, Malat, he has converted the residential area to a business place. This is a clear violation of the lease deed. There are Malat, default clause.
I raised the issue of maintainability. If your lordship kindly sees who are the persons making this application and what are the reliefs being sought for. Whether under this determination, at the instance of this petitioner, the writ petitioner can be maintained in its present form. The grievances alleged is in the nature of public interest litigation. And that too, even if that is maintainable.
Malat, who has filed this deed application?
It will be thoroughly premature because we are yet to take decision. They are not allowing us to take decision.
From the very beginning, they are trying to mislead this honorable court by making this submission. This matter is premature. But what is the subject matter?
Let him satisfy the
An
court.
association was formed.
Let him place his case.
Yes.
And
You are challenging the maintainability issue?
Yes. First
So
of all,
if it is-
maintain.
if the preliminary
Lord.
issues are there.
Let him satisfy this.
Let Mr. Talukdar place his case.
Madam.
Because he's challenging maintainability.
My lord.
Let that be decided first.
Yes.
Yes.
If your lordship kindly come to paragraph 2 onwards. Paragraph 1, the petitioner is an association registered under the Societies Registration Act. Then the petitioner says, the paragraph 2, the petitioner has been constituted to look after the problems and difficulties faced by the people of the area. Shantipalli, particularly the senior citizens, and to promote the interest of the members of the association, etc. Then about the resolution, so and so. So this petition is being made in the representative capacity. The petitioners cannot be said to be aggrieved personally. And what is the challenge? That there was a lease granted in favor of the private respondent number. We are not supporting. Lordship will find our report they have annexed in this rate petition. They cannot allege that we are
No, I have never said
supporting.
so. In the entire REIT application, I have said so that the case.
facts of this
KMDA
case,
have
a lease
supported the
deed-
case of the petitioner.
A lease deed was executed by KMDA in favor of respondent number 8. There were some conditions in the lease that was allotted exclusively for residential purpose. Violating that clause, it is alleged that violating that clause, the original lessee subleased that plot or the building constructed thereon to the other private respondents who are carrying on business there, which is disturbing the locality, the peace of the locality. This is the sum and substance of the grievance.
So you say that it is in the nature of a public interest.
Public interest litigation. What is the relief sought for? Lordship,
So
kindly
the
able to-
response of the petitioner.
Now, my lord, the petitioners are the local residents.
So that is a
They are-
public interest.
Yes, my
litigation.
lord. No, not, my lord. Why, my lord? They are local residents. They are the plot holders. They all are the plot holders and senior citizens. Even the land allotted to the concerned person who has started this business, my lord, he is also the plot holders. They are all adjacent plot holders.
How is your individual interest affected?
Yes, my lord. Because the specific clause. my lord,
Because your society represents the entire locality as a whole.
No, not entire locality.
The senior
That-
citizens of
that-
the locality.
Yes, senior citizens of the locality, they are aggrieved by the conduct of the private respondent number 1, who
So
had.
I'm sorry, sir, this is a public interest litigation. No individual interest is affected.
No, we are individually affected. By what? There are severe vibration. Buildings, there are cracks in the building of the members. My lord,
Yes, but this is in the representative capacity. The association represents all the senior members of the locality. So don't you think it's a public interest litigation?
my lord, how it is public? They are personally aggrieved.
Where are
They are not
Have they
ventilating the
appeared?
grievance of any other
they
persons. They are
approached the court
ventilating the.
Have they approached the court individually? They have not.
My lord, the members are aggrieved by themselves, not that. This is not a fact that they are representing the other person who are not aggrieved. The persons who are aggrieved, they are the members.
Yes.
So they are representing themselves by way of association, registered association, not an unregistered association. It's a registered association, my lord.
Yes, maybe, but it is in the nature of a public interest litigation. No individual person is affected. The entire senior inhabitants of the locality is affected.
Because they all are aggrieved. They all are personally aggrieved.
Considered by the appropriate bench.
My lord, this point was raised earlier, my lord. Your lordship entertained this REIT application earlier.
Show me where it was raised.
Yes, my lord. Kindly see. That order I have annexed. Since new cause of action arose, my lord, liberty was granted to file a fresh. My lord, page 104. Similar point and raised.
This is not this point. Because they
Can
sought
you
to
see
challenge
page
on
page
perusal of
10
our report.
Page 104.
There
This
we.
order doesn't reflect anything.
Then
Well, this, can you see?
that's the
Same petitioners.
And you have withdrawn.
withdraw.
Yes, fresh cause of action arose. Malad, can you see? Fresh cause of action arose because they are pendings of the writ application. Malad, they have bring malad, by way of malad report, they have brought some certain new facts. That is why new cause of action arose. You will also grant a liberty to file a fresh cause of action.
Maybe, but this cannot be entertained by this court. This is the entire locality which is affected. Cannot be dealt with by this court. I'm really sorry.
Malad, we are not espousing the cause of any other persons.
You are espousing the cause of all the senior citizens of the
Yes,
locality.
who are directly aggrieved.
Yes. So that is in the representative capacity.
Malad, a writ petition cannot be filed by representative capacity without the public interest litigation.
You
Malad,
are-
I shall produce the judgment. Malad, kindly, let it remain. Malad, I shall produce the judgment.
Very well.
Let him satisfy.
Affidavit of service. Paragraph, learned counsel for the KMDA challenges the maintainability of the writ petition on the ground that the writ petition is in the nature of a public interest litigation, since the writ petitioner represents all the senior citizens of the locality in question. Paragraph, learned counsel for the petitioner seeks accommodation to respond to the submission made on behalf of the KMDA. Paragraph, let the matter appear under the same heading on 6th July.
6th,
6th
any
July.
day before that. Malad, kindly, they all are senior citizens. There is huge disturbance. Malad, huge sound. Bricks are
So you shouldn't
falling.
be wasting further time. You should go before the appropriate bench.
Malad, so any day, Malad, before day, Malad, I shall one last chance, Malad. One last chance may be given, Malad. If I cannot satisfy your lordship, I kindly refer the matter before the Malad.
27 June.
27. Deeply applied.
27.
We are not supporting the wrongdoings.
Malad, I know, Malad, I have
that is
annexed
meant-
their,
yeah.
I have annexed their report. Malad, they have.
But a petition, when it is.
Our
placed before
support,
the court,
Malad, they have,
that should
Malad.
maintain a.
Malad, affidavit of service filed today.
Take it, take it. Next.
Item 21.
21, I beg to appear on behalf of the respondents.
Malad, I am for the petition, Malad.
But what will I seek is that they have prayed for employment and compensation. But my lord, what will I seek from my lord is to give us an opportunity to file our pleadings in this respect within a particular time frame as my lord will be fixed.
Why pleadings?
Because the cause of action arose in the year, what I find is 2013. Thereafter, a representation was addressed.
Let me place my case first. Then my landed
If you
friend will
want
get.
to submit a report in the form of affidavit, you can do that.
Malad, the case is that due to the mining activities of the ECL, my land has got damaged and also subsidence has occurred. Malad, there is a recent photograph, Malad, I'm handing over. I've been writing to the ECL, Malad, from time and again from 2013. Recently, Malad, I preferred a RTI where they said they have lost all my documents. And they are saying that they are actually making a search to find out the documents. I've again made a representation providing all the plots of lands affected, which has still remained unanswered. My lord, only a innocuous prayer, my lord, that representation may be decided.
Your land is being utilized.
My lord, total, my lord, it's a long schedule, my lord. And they have undertaken mining. Tala, please, if you interrupt, Corona. They have undertaken mining by caving method and also by open cast mining. So thereafter, my lord, lordship will find that the land has suffered subsidence, my lord, and it made unfit for agriculture. And my lord, my claim has to be, my lord, decided. This is my innocuous prayer before your lord.
Well, first, there was no prayer for consideration of the representation. If my lord take note of the prayers, which is at 16, there is no such prayer. So innocuous prayer is not there.
Very well, then pray
My lord,
compensation.
second of all, 2013, you make an application, thereafter no steps taken, finally finding on 2019, you file another representation seeking. You have not explained what you are doing for there is no specific averment that whether your land was taken, how it is damaged, there is no specific averment in the petition. So my lord has fallen from my lord, let us file a report in the form of a FIT, indicating what are the actual facts. Because other 90% of the pages are illegible, we cannot read from it.
What is the difficulty in disposing of the representation on?
My lord, we are willing to dispose of, but this
Upon
was my
hearing
only
the
submission.
petitioner?
My only
That will
submission.
save time,
My lord, we can dispose of the representation, my lord.
and disposal doesn't mean rejection, sir. That should be borne in
No,
mind.
absolutely. On merits, it has to be disposed of. My lord, but unfortunately, there was no such prayer. So my lord,
There can be molded.
My lord, kindly takes up page number 27. I'll
Ask
answer the
for
question of delay.
So if he asks for that same compensation before the authority, what is the
my lord, no.
difficulty?
My lord,
To
they'll
answer
pass
the
that
question
up.
of delay, my lord, kindly takes up page number 27. They have asked me to provide the plots in 2020. Page number 27. It's a handwritten one, but written by the authority.
Yes, this is in 2020. So
My lord, my lord.
And it's a record.
So there is
My lord.
no disputed question of fact.
Where is your representation?
My lord, representation is at page number. My lord, page number 46 is the final concise representation.
So let this be considered within a month.
My lord, my humble submission, can it be within 6 weeks?
Very well.
But only one thing, my lord, they say that they have lost the documents. So they may ask for the documents which
Annex
are
all the
available.
relevant documents with your representation.
My lord.
I'll grant you liberty to produce all the
My lord.
documents. Heard learned counsels for the parties. It is contended on behalf of the petitioner that due to mining activities of the respondents in the land belonging to the petitioner, the land has subsided and become unfit for cultivation. Stop. Several approaches made by the petitioner before the authority for payment of compensation for the same fell on deaf ears. EARS. Stop. The petitioner submitted a representation before the concerned authority on 16th August 2022 in this regard, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents. Who should be the authority to consider?
Respondent number 2, my. The general manager.
The second respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. The petitioner shall be at liberty to place all relevant documents before the authority at the time of hearing. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, in the event the petitioner is found entitled to compensation, such compensation shall be disbursed in favor of the petitioner within a month thereafter. Within a month thereafter. Disposed of.
No, affidavit service may be kept on record.
The allegations made in the petition are
It will be
deemed.
recorded. That's the usual line that I record. Next.
My lord, can I take back that? Can I?
The photograph?
The photographers.
আমি দিয়েছি ওটা ওখানে দিয়ে দেবো তোমাকে
এই ফটোগ্রাফটা ফেরত দিন।
একটা ফটোগ্রাফ
No, my lord, let it be on record.
No, no,
He
no,
will
no.
serve us. He will give us a photo.
Next,
Item number 22.
22.
I'm for the petitioner. This is my application, my lord.
So let there be some time. On prayer of the state respondents, the matter is adjourned. Let the matter appear under the same heading on 11th July. 11th July.
এই পড়ে নাও।
Number 24.
I'm for the petitions, my lord.
Yes, served.
My lord.
Several private respondents.
My lord, I've served.
Who is appearing for the state?
First time this matter is appearing before this.
I do not find, may I request Mr. Dev? Please serve a copy to me.
My lord, I use it. I use it.
Yes,
No. My lord, the matter relating to the unauthorized construction of the State Highways Act, my lord. The representation made annexed P6, page 39, my lord. ST. No, assistant. P2. Assistant. Respondent number 3 is the competent authority, my lord.
let it be considered. Affidavit of service. None appears for the respondents despite service. Mr. Dev, who is present in court, regularized quorum, copy service and direction. For the state respondents. Paragraph, the petitioner complains unauthorized construction made by the private respondents by encroaching upon a portion of the PWD road adjoining his property, thereby obstructing his egress and ingress. The petitioner submitted a representation before the concerned authority in this regard on 20th September 2022, which is yet to be considered. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents at the highway subdivision. Three. That the third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of, which are
Number 25.
25, my lord, I am appearing for the petitioner. My lord. I will already serve upon all the respondents. See the affidavit of service. Now, here is the case is that. Yes, he is on the. My lord, here is the
I am
case.
for the WBSC TCL.
My lord, here is the case. My lord, the petitioners are the legal heirs of the landowner.
TCL should
Now
have been,
the
my lord, the TCL should have been made party because the substations now belongs to the TCL Transmission Company Limited. And Landed Smith made party to the WBSC TCL. That to me, lord,
It is the WBSC DCL.
now TCL. Now it is under the Transmission Company Limited.
Transmission Company Limited, well, so for the West Bengal Board of, well, the Board and Distributions Company Limited, that is the.
No,
WBSC.
Distribution Company Limited. Initially, it was under the board.
Yes.
Now the bifurcated notification, there are two companies, Distribution Company Limited and Transmission Company Limited. So Transmission Company Limited should have been made party first.
The transmissions company limited, let the address be to be handed over. Or let me see. Address টা তো জানি না।
এ দিয়ে দেবো। না দিয়ে
কি party করতে হয়? I think so, my lord, I have already made an application for my lord, which the land has been acquired. The my lord, electricity department has not been used. That is useless. Now I have my lord, the compensation amount was paid to us. Now we are willing to pay that my lord, the amount to be paid my lord, along with the interest, so that the land to be returned. Since my lord, the land is useless or without any use or without any acquired.
The electricity company has acquired your land or acquired the user?
No, my lord, I am the landowner.
By the government.
Land was acquired the government.
We are the requiring body.
Yes. Special land acquisition has been acquired. Thereafter, it is been transferred to the electricity department. Now, electricity department 132 kV stations has not yet been used, or it has not been erected. So, free land is been fallen down. Now, this compensation amount has been paid to us by the special land acquisition officer, so that the amount to be returned with along with the interest, so that the land to be returned to us.
How can
So
it be
this
divested?
application, my lord,
There is no such
Once
law.
vested, how can it be divested?
only my lord, make applications my lord, to the my lord, special land
Is
acquisition
there any
officer.
scope under the law?
No, now questions is this, my lord, that free land has been
The
disturbed.
land is admittedly vested, you have received compensation.
Yes,
So is there any provision for divesting of vested land?
no, divested, my lord, in which has been my lord,
Unless-
acquired. That land may be my lord, returned with my lord, the money has been returned.
There is the provision, sir, please show me.
My lord, then my lord, your lordship kindly will adjourn this matter, so that I think so, but there is no
Land once
provision.
vested cannot
But
be
my lord,
But
ultimately exhausted applications, my lord, page 8. My lord, I made an applications to the land authority, my lord, as district magistrate, as well as the land acquisition officer. Let him consider, my lord, whether any provisions or my lord, if
Please
otherwise,
show me the
otherwise.
provision, how this application can be considered.
There is no provisions, my lord, as per my little.
If the authority has been considered, take a decision. So applications to be considered.
Substation আছে তোমাকে দেবে কি করে?
No, already substation has already been installed, well, everything is
Or otherwise,
completed.
my lord, the private respondent hearing that what the free land has been used, they are trying to use. So my lord, I think so, let there be directions not to take any decisions by any other third party.
Please show me that your application can be considered by the authority
My lord, my lord,
in
my lord.
accordance with law.
In accordance with.
That there is no law which provides for divesting of plot after vesting.
Well, let them decide by the authority.
How?
No provision.
There is no provision to decide.
Or my lord, take steps by the electricity department.
Will be done, sir, please.
No,
show me
that
the
is, my lord, that is the headache of electricity
It is
department.
my lord, this land has been.
This land belongs to the
electricity.
electricity company.
Given to your land by way of acquisition, you have
Yes.
received compensation. The land is vested with the government.
My lord.
The government can choose to do anything with the land under the law.
But the government ballot is sitting tight over the matter, but by not enacting or by not any
You have received
another third party, my lord, another
Are you
third party.
aggrieved by the compensation? No.
My lord, another third party has been used this my lord, area.
The government and the third party, you have nothing to do there.
No, my lord, I am not saying that. If it is not returned or there is no any provision, that the land should be kept in the state.
Yes, land belongs to the state.
But my lord, now the questions for 144 proceedings was initiated. I have already annexed.
Withdraw. I have to
and
dismiss the
this-
matter.
My lord,
I have to dismiss the matter. If you can withdraw, I can give you the opportunity.
then my lord, kindly
Nothing
keep
can
it.
be done.
keep it, my lord, my lord, ও জানি সবই জানি
না
তাহলে প্রাইভেট রেস্টুরেন্টের সঙ্গে আমার ঝামেলাটা হবে
And because private রেস্টুরেন্ট
রেস্টুরেন্ট দেয়ার other third party has been
তোমরা
taken.
ওখানে বোঝাও
That is between the government and the private.
Yes.
And you have.
How
no
you are
right to
interested?
say. You have taken compensation for the land. It is a vested land.
dispose of it.
Your loss is dispose of this matter without
Dispose mean dismissed. What dismiss?
Dismissed.
then my lord withdraw this case.
তো সেটা বল।
Dismiss করে লাভ নেই।
No, dismiss করতে হবে
না dismissal এর অনেক
Learned-
পাপ আছে জানো না বুঝলে? পাটা কেটে
The
যা থাকতে পারবে তাই পারে।
affidavit of service.
দুটো পা যদি কেটে দাও
Learned person
নিয়ে নাও
of the
তাহলে কিন্তু আমার
petitioner.
বুটি থাকবে আমার বেঁচে থাকারও লাভ
The,
উল্টোই বলবো
it is submitted on behalf of the petitioner that the petitioners does not, do not intend to proceed with the matter any further.
হ্যাঁ ঠিকই তো।
Paragraph in view of the above, the petition being WPA such and such is dismissed for non-prosecution. There shall however be no arrest of cause. Next.
our name may be Malad appeared.
Yes.
Our
Yes, yes, please give the name.
Number 26. Wait, please, Sir Archibald. This is that transfer of the Salt Lake property,
The fees.
the fees. My lord wanted them to take further instructions and come back, my lord, taking into consideration, my lord, page 32. So I don't know, my lord, whether they've taken instructions or
Yes, Mr. Gandhi.
Well, you lordship, the last was you were directed to take instruction with regard.
7 was there, a private respondent?
No. 7. There wasn't any private. Respondent. 1 and 2, my lord. ছাব্বিশ নম্বরটা দিই
আমাদের তো টলার কি আছে? ওর বাইরে তো আমি কিছু বলতে পারবো না।
I don't know from where this respondent number 7 has.
Sir, this is WPA number 28819.
Yes,
Correct.
only 1 and 2 are there.
1 and 2.
অম্লান কোথা থেকে এগুলোকে জোগাড় করে আনছে দেখুন রেসপন্ডেন্ট নাম্বার 7 রেকর্ড করেছে
Order.
7 নেই
এখন যারা ইউটিউবে যাবে তারা কেউ যদি আমেরিকায় বসে আছে এখন সে মামলা হচ্ছে সে এখানে দেখতে হবে
তুমি ওইটাই বলবে
শুধু একটা অর্ডার করবেন inadvertent error has been into the order passed on April 12th. Which said order. এইটা inverted comma রাখবেন the advocate থেকে respondent number 7. Yes, yes, Mr. Gandhi.
Well, from the last question, lordship directed us to take instruction with regard to page 68. That notification dated 22nd of June 2012 is applicable in case of the petitioner or not, my lord. But our, yes, ma'am. Page 68, ma'am.
Yes, this is to a stranger.
No, our respectful subject before your lordship, it is applicable in case of all the parties, my lord. My 2 others, my lord. It hasn't specifically written, my lord.
Yes, but
Kindly
this is
see.
a case of strangers.
No, my lord, not stranger.
Please
In
come to
all
the
cases, ma'am. Yes, ma'am. May I read the entire notification? Kindly allow me.
Yes.
My lord, there are about 13,000 residential plots in Salt Lake Township. Most of these plots have been leased out to various persons for residential purposes as subsidized rate. The lease deeds were executed for 998 shares with certain terms and conditions. And it has come to the notice of the government in the UD department that many cases possession of plots is transferred to third parties on the strength of strength of various documents such as general power of attorney, agreement of lease, tenancy, and will.
To a stranger.
A stranger, and that through such document do not amount to a transfer of lease in law. In effect, possession of the plot is being parted with the original lease.
Parted with by the original list.
Most of the lease deeds executed by the government contain restriction on
assignment,
transfer of the nature as being carried out at the present, and these transfer without the government permission is not being on the government.
Not binding on the government.
Next paragraph. The government in the UD department has earlier allowed transfer of leasehold right in respect of plots of land at Kolani Township as well as for non-residual plots of land at Salt Lake Township by imposing permission fees and on fulfillment of certain other terms and conditions since 2005. The next one. In the like manner, and also in order to put an end to such unauthorized transfer.
Unauthorized.
In like manner, kindly my point, in like manner, and in order to put an end to such unlawful transfer as well as to increase revenue in government exchequer, the government has been pleased to order that the government of West Bengal may allow the lease of residential plots building thereon of Bidhannagar to transfer his leasehold right to others, not my third party or stranger, to others, for an expired period of lease term inter alia by imposing transfer fees at the rate of 5 lakh rupees for the time being, and such other terms and conditions as may be fixed from time to time. To seek the provision of the government to transfer his leasehold right to the others, the lease mutated lessee shall have to apply to the principal secretary in the government of West Bengal UD department, such and such ballot, stating his intention for such transfer. Now kindly see, the transfer fees, however, will not be applicable to the cases that are within close blood relation. Only when a close blood relation are, they are not allowed to pay transfer fees. Kindly see, all the or any others person, not my stranger or third party.
So 1, 2, and 3 are not close blood relations, you say?
No, close blood this is not issue, my lord. They are the others, my lord.
Transfer fee is not applicable in certain cases. So you say that these petitioners are not covered?
Transfer fee will not applicable in case of a close blood relation. They are not the close blood relation.
What they?
They are the co-lessee. They are not the close blood relation.
They are co-lessees.
Co-lessee, my lord, not the close blood relation. my lord.
They are not outsiders or others.
Exactly.
But others, my lord, they are others. They are falls under others, my lord.
That's all a submission.
Kindly looks to page 32, everything is clear on them. 32. Looks to Miller paragraph
Transfer
9.
will only not be applicable in case of the close blood relation. But they are not fall under this, the
Looks to clause 9. In case of a lessee in favor of 2 or more individual lessees jointly, any one of such joint lessee will have the right to transfer his or share to take to the other co-sharer or co-sharer.
We are not
He
debarring
doesn't
them
deny
to
the right.
transfer.
He says that right is subject to payment.
Subject to payment of my transfer.
Of a right to payment where there is an unauthorized transfer.
No, my lord.
Where I am authorized to transfer, like in a clause 17, my lord, lease deed. You cannot, my lord, ask for, my lord, where I am transferring somewhere else outside to others, it's then within the co-lessees, my lord, there is no right. It is an authorized transfer. It's not an unauthorized transfer.
Is that all?
No, that's it.
My lord,
Yes.
if they want to transfer, they have to pay one of the transfer fees. Nowhere it has been written.
The iteration will not help, sir. I'm sorry. Anything new to say?
No.
We cannot go between the my lord.
The
Our
terms are very
submission, my lord. He will please approve, my lord. He will have to pay the transfer fee as because it is not within the close blood
It
relation.
is within the lessees. The lease was granted to 3 people. 2 of them want to transfer to the third one.
That is the co-lessee, my lord, but they are
That is
not
a
the close
co-lessee.
blood
Yes. Reserved. No further instruction is necessary from your end, I believe. Yes. Order reserved. Yeah, order reserved. Yes, next. Order reserved.
Item number 27.
My lord, I am for the petition. What happens? What happens, my lord? My lord, lease deed was executed on 9 April 2018. And my lord, the handing over position was on 7/12/2018. My lord, come to page 23 first. Page 23. Yes, my lord. Now, my lord, kindly see.
Page 20.
23. Yes, my lord. Mining lease deed was registered on 9 April 2018. And the handing over position was 7
December 2018. That is 8 months delay. I have no handle. And my lord, my mining lease deed has been just now expired. I mentioned the matter earlier, but due to the business of the court, I have not been able to give reply to your lordship. My lord, your lordship fixed for several dates. However, my lord, I made a representation. My lord, come to page 33.
You're asking for extension?
Extension. Now, my lord, the mining lease deed has already provides that where a deed the thing to Part 9, Clause 5. The mining lease deed, force measure. My lord, your lordship has passed an order previously. I am handing over the order. My lord, where it has been. And my learned friend also appeared in this matter, my lord. Where, my lord, I am bound to get the extension. Kindly go through the first judgment, my lord. I am handing over the second judgment also. Huh? No, no, my extension extension. কেন ফোর্স মিলে তোমার কাউন্সিল আছে দেখা যাক না কি দাঁড়া that will be considered phase 33 will be considered by the authorities. Then you will get all the relief request with all the that you are taking appear করেছিলে I appear করি দাঁড়াও না হয় দেখো নাও মেলার সেকেন্ড জাজমেন্ট সেক্রেটারি দিন তো মাইলর তো জানে Your lordship extended the second on the judgment, and your lordship's view was the petition from such and such was extended, which the petitioner was unable to carry on mining operation due to no fault on his part.
This is issuance of transit pass.
No, my lord. Mining lease deed was executed on 9th April and handed over on December. There were 8 months had been delayed. That should be extended at least. And on the basis of the force measure, where it has been clearly stated that due to the action of the others, not in the fault of mine, it should be least, this should be extended. That your lordship passed the judgment on the basis of that, on the basis of force measure, and as well as where I have no authority or due to my fault that I have been.
So let them consider your representation in terms of clause 5 of part 9. Yes?
For extended, my lord. Yes, my lord. Kindly.
Where is the copy of the deed? It is in your petition.
Deed I have handed over to you once. The original one. Deed the deed.
Where is your representation?
Representation page 33, my lord.
Being the highest bid, heard learned counsels for the parties. Being the highest bidder in an e-auction floated by the respondents on 2nd August 2017, 2017, and upon depositing the prescribed fees, the petitioner was granted long-term mining lease for a period of 5 years. V-Day deed of lease executed and registered on 6th April 2018 and 9th April 2018 respectively, and possession of the block in question was made over to the petitioner on 7th December.
7th December,
7
page
December.
23, my lord.
7 December.
7 December. Page 23.
The petitioner was therefore unable to commence mining operation till 7th December 2018. Stop. Also, comma, due to COVID-19 pandemic, comma, the petitioner was not in a position to continue mining operation. And for the said reasons, comma, has filed a representation before the concerned authority for extension of the period of lease. Concerned authority on 13th December 2022 for extension of the period of lease. Stop. The said representation is yet to be considered. Stop. The petitioner pays for a direction upon the authority to consider the representation at the earliest. Representation at the petitioner, learned counsel for the petitioner, draws the attention of this court to clause 5 of part Roman 9 of the deed of lease, which indicates that if through force majeure, the fulfillment by the lessee of any of the terms and conditions of the lease be delayed, comma, the period of such delay shall be added to the period fixed by the lease. Stop. Additional submitted representation. Paragraph, it is submitted on behalf of the respondents that the fourth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 6 weeks. Within 6 weeks from the date of communication of this order, in terms of clause 5 of part Roman 9 of the deed of lease, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week. Disposed of exactly.
Lease deed that we-
Next.
Number 28.
Lord, I am for the petition. I am for the petition. Lord, first annexure P4.
What is the matter about?
Page 28 matters, my lord, correction of records and also interchange from Atapukur Mauja, Berg Mansur district, so not 24 Kalpanas to Umarsa Chowk Mauja.
This is under the Land Reforms Act.
Yes, Lord.
This court will not have jurisdiction. It's a specified act. You have to approach the appropriate forum.
Yes.
Yes.
Next page, my lord, the authority concern considered. But till date is still pending, only consider the annexure P5 by the respondent number 3.
This is squarely under the Land Reforms Act, sir. This court will not have jurisdiction to deal with it.
Only consider, my lord.
Still, this court will not have jurisdiction. I have to dismiss on this ground. I can give you the opportunity to withdraw. You can approach the appropriate forum. Yes? What do you choose to do?
Withdraw this. Liberty is given.
The matter pertains to the West Bengal Land Reforms Act 1955. Paragraph, learned counsel for the petitioner seeks to withdraw the petition and approach the appropriate forum for redressal of the grievance of the petitioner. Paragraph, in view of the above, the petition being deputy such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, there shall however be no redress costs as in certified by state court. Next,
Evident service get to it.
affidavit of service.
My lord, I am appearing for the
Number 29.
I am appearing for the petitioner. My lord, affidavit of service has been filed before vacation only with regard to service of respondent number 8 and 9, who are my supporting. They are these studios. It was unserved. I have served as per your lordship's direction. This is the affidavit of service. By hand it was served. My lord, there is no at the threshold. I may candidly, my lord, say before your honor that your lordship that there is no scope for any interim order. Well, actually, what happened, your lordship, the land was standing in the name of my grandmother, Binapani Devi. 67 kathas of land at Howrah. It was taken under acquisition in 1969. Thereafter, till date, the land is in my possession. And if your lordship kindly take the trouble to come to page 18 onwards, it is admitted by the respondent that the land was still not used for any beneficial purpose and for the purpose which was taken. So what I am praying, my lord, let them file affidavit, my lord, because it cannot be decided. There is no scope for interim order.
Just let us hear the
Yes.
response.
My lord, Mr. Shibujyoti Chakraborty is appearing for the HIT and due to his personal difficulty, he is not come court today, my lord.
Let there be an affidavit, my lord. I am not praying
For
any interim
not
order.
today,
If
my
your
lord.
lordship kindly once comes to page 18.
Because they are not in a position to make their submissions. Let them come back.
My lord, actually, because of my before vacation, actually, what is the difficulty? I am in possession. I have, my lord, annexed the photographs also. But now, my lord, they are trying to take the possession. That is the difficulty. So what I am beseeching, that is the reason I am not paying any interim order also. So if any order of affidavits is filed, I don't think there will be prejudice.
Affidavits may not be required. They may come back with a report. That may suffice.
Then your lordship
So let
direct,
them come back. Let
your
them come
lordship,
back.
my lord, with great respect, they'll let them file a report.
Will you come back with a report on the next day?
Yes.
Yes.
Yes, my lord. My lord, in this matter, Mr. Shishwana Bandyopadhyay and Orko Kumar Naik appearing on behalf of state.
Here main contention is HIT. They are the main answering respondents. If your lordship kindly come to page 18, 19. my
Let there be a date. Report also I will not
Yes.
call for at the moment because they are not in a position to make any kind of submission at all.
Yes.
Let the senior friends appear.
So, my lord, your lordship.
My lord, may I submit one thing?
Yes.
My lord, actually, the land in question actually acquired in 1962. And in respect of that land, the specific award has been given and it was subsequently received in 1996. As it is revealed from the annexure
Yeah, that I am
P1,
admitting, I have
P1 of the writ petition
Yes.
and by the right to information report supplied to the advocate of the petitioner, also the advocate.
Yes.
And which main condition is there, which land actually award has been one hand petitioner received the award, on other hand petitioner taking back the position, actual position. This is the contradictory statement.
That is their difficulty. Award has been given and under protest it was taken. I have annexed this. That is P1. Your lordship kindly once comes to page 80. I'm trying to give the answer which fell from my learned friend. Land was taken for beneficial purpose. That is the modus operandi of land acquisition, either railway or something. Now, your lordship kindly see. As per available record, such and such was acquired for the project of general improvement scheme of Howrah Improvement Trust under notification 62. As per office record, payment was made for LA case number, but possession was not delivered to HIT. Photocopy of plan above holding is enclosed herewith, but certified copy of gazette is not available in this office. However, he is also advised to make prayer for the same in office of Howrah Improvement Trust. Now, your lordship kindly take.
The advocate or record for the Howrah Improvement Trust, he will not come to court.
She's
বলছে তো
mentioning the
সেটা।
matter. She's appearing.
Yes, now, yes. Now, my lord, the second, my lord, your lordship kindly come to page 20. Page 20. The said scheme for which the land was taken.
Was withdrawn.
No, yes, not withdrawn. It has not been implemented. That is their document. In 2017, the said scheme has not been withdrawn by the HIT. The said scheme is in the process of implementation. 1962. 2017, and my advocate on record has already given representation. No answer has come. That is page 51. I don't understand what my learned friend, I admitted.
The land has been admittedly vested. You have
The
received-
land not vested. The land has been taken.
Acquired by the Howrah Municipal.
The land has been taken under acquisition for a definite scheme.
and you have received the.
Yes, under protest. That is in the 1962.
You have not taken any further steps for enhancement of compensation?
I have not taken,
So
but
where is
possession,
the provision for divesting of a land which is already?
that I
vested?
will show in the next day.
Please come back next.
Yes, kindly fix a date
I
and.
don't think any report is necessary for the time being because the documents are on
Yes.
record. Please
Yes,
come back.
your lordship is directing for filing a report.
No,
Very well.
your documents are sufficient, right?
Yes, sufficient,
Please
and
come back.
their document says that that is not implemented.
But after you have received compensation for the same.
Under protest, your lordship, I am here joining one issue. Your lordship kindly appreciate one thing. Land was taken by the government for beneficial purpose or some implementation. It is not for any merely, it cannot be go. If for years together, after 50 years, that my lord scheme is not implemented by the government and possession is in my possession, they even failed to take possession of the land. So I am praying for retention of the land because my lord government cannot take the land without any beneficial purpose. That is the core of our constitution. There are judgments of Honorable Supreme Court, even double of the amount has to be paid if that is not made for beneficial purpose. And in 2017 also.
Please come back. Let us.
Yes, I will come back. Your lordship
Affidavit
kindly
of
fix a
service.
date so that the matter may be
None
heard.
appears for the seventh and none appears for the eighth and ninth respondents despite service.
Yes.
Paragraph on prayer of respondent numbers 1 to 7. The matter is adjourned. Paragraph, let the matter appear under the same heading on 11 July.
My lord, this month, my lord, your lordship kindly appreciate.
This month will be difficult, sir. This month will be difficult. There are several matters. Come back on 11 July. Please be ready on the next occasion.
When your lordship is fixing on
11 July.
11 July. My lord, this month, if possible, my lord.
This month will not really be
Then
possible.
first week of July, my lord, little earlier,
Very well, 7 July.
7 July. My lord, let it be at the top so that the matter may be heard. That is my only.
So many prayers cannot be allowed, sir. I have shifted it to 7.
Very well.
Rush to 7 July.
7 July. Yes.
Next one.
Number 30.
And for the petitioner, my lord, I served upon all the respondents. That is effective.
Several respond private.
My lord, all are
respondents.
served. All private respondents are served.
এভিকশন তাড়াতাড়ি চেয়েছে আমার সাথে আমি করবো না চেয়ার সরিয়ে দিই ঠিক আছে বস
Yes, who is appearing for the state?
I am appearing on the.
You are appearing for the state? Yes.
My lord, unlawful construction in contravention of the provisions of the 1962 Act, my lord. That was yet to be
Government land.
considered.
Government land.
My lord, government. Page 63, my lord, and SRP 6.
Page
63. The concerned sub-divisional officer is the.
Yes, Mr. Mathur.
My lord, the representation may be considered.
Affidavit of service.
My lord, after hearing all the, my lord, the private
Private
respondent,
respondents
because
also,
they are
right,
the
right.
occupants.
None appears for the private respondents despite service. Paragraph, the petitioners claim to be the recorded owners of the plot in question and complain that the private respondents have encroached upon public land, encroached upon government land adjoining their plot, comma, thereby obstructing their egress and ingress. Stop. The petitioners submitted a representation in this regard before the concerned authority on
22nd November, my lord, page 66.
22nd November 2022, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that the
Respondent number 3.
eighth respondent.
3, my lord. The sub-divisional officer holder.
This is Holdia, this is irrigation. The third respondent be directed to.
My lord, the land belong to the, my lord, irrigation and waterway department.
So it should be the eighth respondent.
Collector. Collector.
Let it be the eighth respondent in that.
Yes,
No,
eight respondent.
That is the sub-divisional officer, the irrigation. And then SDO, my lord, the concerned authority. SDO. SDO is the authority.
This is also SDO.
No, that is irrigation. SDO of the irrigation waterways department, my lord.
Mr. Mathur?
SDO is the competent authority. As a collector.
SDO at the part of the removal, but first of all, my lord, the
SDO.
SDO is the on the part of when that removal is to be an eviction. But at first, it is to be determined first whether it is
Let
under.
SDO take necessary steps for demarcation.
My lord, that should be taken by the irrigation and waterway department.
That is what happens. The SDO will write to the irrigation department for taking the steps. The third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted on behalf of the petitioner dated such and such within 3 months.
Within
Because
3 months.
proceeding has to be initiated.
Respondent number 3, my lord.
3. Within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, in accordance, in accordance with law.
Irrigation waterway.
Disposed of. Check.
And my lord, after giving opportunity of hearing to the.
To all of them.
Irrigation and waterways department শুনবে তো হ্যাঁ তা না শুনলে কি করে হবে irrigation waterway ছাড়া
Number 31.
Lord, I am for the petitioner, my lord.
Lord, I beg to appear on behalf of this.
Lord, I am praying for liberty to add the party under RAC, my lord. That is a mistake on my
That
behalf,
is
my
not
lord.
required. That is not necessary.
Lord, that is the
Land was
authority
acquired
of
and
the, my lord.
compensation has already been paid below in the year 1992 under 11(1) Land Acquisition Act. He has been paid below compensation. Now he wants land in the 2022.
Who has been paid compensation? The petitioner.
Your lordship, my lord.
My lord, I am the land loser candidate, my lord. At the time of acquire my land, my lord, after acquire my land, compensation given, my lord. Thereafter, my lord, during that period, my lord, as a land loser candidate, the government has some assured to whose land has been acquired in the purpose of petrochemical petrochemical project. They will be provide another land as land loser candidate, my lord. That's why, my lord, I am praying before your lordship, and representation has been submitted before the authority. But my lord, due to mistake on my behalf, my lord, the authority who is the RAC, RAC, my lord, Rehabilitation Advisory Committee, who is the actual authority, my lord. He has not made party, my lord. Due to that, I am liberty to make party him, my lord.
Lord, for
Seven.
Hon'BLE Petrochemicals, Lord, land was acquired in the year 1992.
My lord, page
And,
16, kindly.
your
consider,
lordship
my lord,
knows,
page
my lord,
16. I have
under
made
section
application
11,
on that.
11(1), compensation has been paid in the year
They have
1992.
submitted that
Now he is
information,
coming,
He's asking for consideration of his representation.
my lord,
I will not go into merits. Let the
My lord.
representation be considered.
lordship.
my lord.
Is there any scheme of the government?
There is
to
no scheme.
provide
That's
for
why
land?
I'm
The land
submitting.
users?
My lord,
But
other,
better be taken up next week, my lord. I get information from the scheme is there.
scheme is the,
But I will get
other
actually-
villagers also, my lord, acquired the land, my lord.
This better be fixed.
So please show me the scheme. so
Yes,
that
my
the
lord,
authority
next
can
week, my lord, and in the meantime, I'm praying
There
for
is no
liberty to
scheme.
add the party, my lord, RAC, my lord.
Add the party,
Yes, my lord.
let's liberty. be
Liberty, my
granted.
lord.
On prayer of the petitioner, liberty is granted to implead whom?
RAC, my lord. RAC, my lord, Rehabilitation Advisory Committee.
The Rehabilitation Advisory Committee, give the detail. The address.
Chairman, Rehabilitation Advisory Committee.
Chairman, Rehabilitation Advisory Committee,
मेरे party as respondent, my lord.
Haldia,
Haldia, man.
Haldia, Purva Medinipur, as respondent number 7 in the writ petition. Paragraph, the constitution of the writ petition be amended accordingly. Paragraph, on prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 6th July.
6th July.
Please come back with the scheme.
Yes.
Next.
Number 32.
Lord, item number 32, my lord, I am for the petitioner. My lord, on last occasion, my lord, the learned advocate, Mr. Ramchandra Guchai, my lord, appeared for the state. My lord, pressed for time to file, my lord, report in the form of affidavit. And a copy served upon me. My lord, I have got the copy, my lord. My lord, I want to
But the
file
report
exception.
Report is not there.
But he has served upon me, my
Who
lord.
is appealing for the state? No one.
Mr. Ramchandra Guchai.
You want to use an exception?
Yes, ma'am.
None appears for the state respondents. Paragraph, learned counsel for the petitioners seeks to use an exception to the report in the form of affidavit, comma, a copy of which has been received by learned counsel. Such report is not on record as yet. Paragraph, let the matter appear under the same heading.
But a short date may be given. Within 7 days, I will file.
On,
my lord.
not 7 days, sir. Come back on 6th July.
6th July.
Please serve an advance copy.
My lord, my lord.
6th July. Sure.
DW.
Next.
Number 33.
Petitioner.
Lordship, Mr. Siddiqui is appearing on behalf of the state. He on his legs before the Honorable Division.
Lord, on the last occasion also, my lord, it was urgent, my lord.
On the earlier occasion, no one appeared at all.
I appeared, my lord. The
Who's
state
appearing
also,
for the railways?
but she's appearing.
You are appearing for the railways?
Appearing for the DFCCM.
Please be ready on the next occasion, madam.
My lord,
Let
may
me
I
again
come
adjourn.
back tomorrow, my lord?
Not tomorrow. I have to give a date. This month will not be possible. I'll come back next month, early next month. On prayer of the state respondents, the matter is adjourned. Let the matter appear under the same heading on 5th July.
5th July. My lord, the compensation part is involved, my lord. My lord, the recent documents that I have received, my lord, that the plots in question are mentioned in my writ petition and I have not been, my lord, dealt with. My lord, so there is the apprehension, my lord, that the order will be passed, my lord, and my writ petition will be infructuous.
So do you want to come back with a supplementary affidavit?
If your lordship directs, I can, my lord. I will,
Direction, if you want to, if you feel it is necessary, you can be granted liberty.
I can only, my lord, rely on these documents. There is no.
They are
need, my
already
lord.
on record.
No, my lord.
So
They are
how
not
will you
on.
rely on them?
My lord, I will come back with supplementary. I was my lord, humbly
You need to
beseeching my lord
put
for
them
a
on
shorter
record.
date, my lord. For a shorter date, my lord.
Very well, 29th June.
I'm grateful. my lord.
Mashu, 29th June.
Very much. I'm so grateful. my lord.
Next.
Number 34.
I'm for the petitioner. My lord, the state respondents were to submit a report in the form of an affidavit.
Lordship, affidavit is ready. We just need 2 more days time, Lordship. Just
Yes.
affidavit is ready, Lordship. Just need 2 more days.
So in that case, let the interim order be extended.
Let them serve us an advance copy. We'll come back with an exception.
Learned counsel for the respondents seeks extension of time to submit the report in the form of affidavit as called for. Paragraph, such report be submitted on the adjourned date upon service of advance copy to the petitioner. Paragraph, on prayer of the petitioner, liberty is granted to use an exception to the report, comma, if required. Paragraph, let the matter appear under the same heading on 13th July, 1-3. Paragraph, the interim order granted earlier is extended till the adjourned date.
Number 35.
I'm for the state, my lord. Led by Mr. Sheikh Mohammed Ghalib.
Page 19 is the complaint of petitioner that the private respondent raised construction over our
Have
PWD
you
land.
served the private
Yes,
response?
yes. Well, the last page 19 is my complaint. Respondent number 8 is to be directed. The assistant engineer PWD Krishnanagar.
Yes, my lord.
The Lordship will get the last page. After affirmation, my lord, I have obtained the track report.
Yes.
Page 19 is the representation. Lordship with the
So let
direct.
that be considered.
Yes, ma'am.
It's PWD road,
Yes,
Yes.
64 Act.
64. A representation addressed to respondent number 7, but copy forwarded to respondent number 8, he has to take.
Affidavit of service, none appears for the private respondent despite service. Paragraph, the petitioners claim to be the recorded owners of the plot in question and submit that the private respondent has raised unauthorized construction by encroaching upon a portion of the PWD road adjoining their plot, comma, thereby obstructing their egress and ingress. Stop, the petitioners submitted a representation in this regard before the concerned authority on 2nd January 2023, which is yet to be considered. Stop, the petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the 8th respondent, 8th.
Well, Lordship, kindly direct the concerned respondent authority. That would be better because.
Respondent number 8, my lord, the assistant.
Concerned respondent is a very
Assistant
vague
engineer.
order.
Okay, all right. All right, assistant engineer is the authority, but since the letter has been referred to executive engineer, that's
Copy
why.
has been sent to the assistant engineer.
All right, fine.
8th respondent to consider the petition in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the 8th respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondent, comma, in accordance with law.
Great.
Disposed of, which are clear.
Grateful, my lord.
Number 36.
Your Lordship, Mr. Ansar Mandal is appearing for the state.
Yes.
Is it due to some personal reason he's not in the court right now? Your lordship can kindly grant us passover.
Passover is not possible in this.
Then your
matter.
lordship can, not today.
Not tomorrow, I've give a date. On prayer of the petition, on prayer of
But
the
it
state
was-
respondents, the matter is adjourned. No private respondent in this matter.
But kindly consider the nature of acquisition. By putting a placard on my land, it has been indicated by the authority that the land has been acquired.
Let the matter appear under the same heading on 3rd July.
Can it be a little bit earlier? Because it was at the bottom, it was mentioned. My lord had been pleased to upgrade the matter. Yesterday it was mentioned.
3rd July, it will appear.
As your lordship.
Great.
Number 37.
For the petitioner, affidavit of
And for the private respondents, lordship.
affidavit of service.
What about the state?
It is, my lord, unauthorized encroachment.
Who is appearing for the state?
State. My lord, I have served the copy. Who is appearing?
May I request? Please serve a copy to Mr. Dev.
Copy.
Yes.
My lord, petitioner's premises is obstructed by constructing park structure in the frontage of the petitioner's premises. It is PWD road, my 1964 Act. My lord, the petitioner made an application to the executive engineer. My lord, kindly see page 31. Executive engineer, he did not, my lord, considered it, and therefore, my lord, filed this
So let
application.
this be considered.
Yes, yes.
As per evidence.
Lordship, kindly allow me to use affidavit, lordship. To use affidavit,
Not
lordship.
necessary, madam. Make submissions if you want to.
Lordship, then on the next I'll make a sub.
Yes.
Lordship, I want to use the affidavit in opposition.
Not necessary at all in this matter.
Lordship,
to make
the
submissions, please
the allegations made by the petitioner against the private respondents are completely incorrect, lordship, because the business I'm holding, I'm paying regular taxes, and also
It is your own land.
it is, in that regard, I have to take instruction, lordship.
You will be given an opportunity of hearing from the authority, right? And record your submission. Affidavit of service. The petitioners claim to be the owner of the plot in question and complain that the private respondents have raised unauthorized construction by encroaching upon a portion of the PWD road adjoining their plot, thereby obstructing their egress and ingress. Stop. The petitioners submitted a representation in this regard before the concerned authority on 7th November 2022, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the private respondents that the private respondents have been carrying on business in the disputed plot for several years. That is your submission.
Yes, lordship, and I have tax receipts and registration certificates to that effect.
And possess tax receipts and registration certificate in support of their contention. Paragraph, learned counsel for the state respondents submits that the third respondent be directed to consider the representation submitted by the petitioners in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents.
Kindly make it 2 months.
Proceeding has to be initiated. Demarcation, then proceeding, it will take some time. Evidence has to be led, 10-3, in accordance with law. Disposed of, etc. Is good. But a none appears for the state respondents despite service. Mr. Their appointment regulars. Thank you. Yes, next.
Madam. No, 38.
May please lordship, I am for the petition. On the last of the lawsuit, director has to, my lord, file the report in the form of affidavit, my lord. My lord, I am filing today and my lord, the copy in course of this day, my lord, I shall hand over. This is not ready, my lord. This is not stitched, that is why, my lord.
You have not handed over a copy.
Yes, in course of this day, I shall, my lord. Sir, my lord.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph, learned counsel for the state respondents undertakes to make over a copy of the said report to learned counsel for the petitioners in course of this day.
Yes.
Paragraph, let the matter appear under the same heading on 6th July.
Not 39, my lord. I am for the national health authority.
Let me take the file.
To submit the report. My lord, the project director is out of station, my lord, 2 weeks time.
And 19th of April, lordship directed to file report.
Yes, my lord. My lord,
So
it's
after
a-
2 months
as per
left,
my
my
lord.
lords, no
Joined, my
report.
project director joined, but he is out of station, my lord. He can to this. He will return tomorrow, my lord. 2 weeks time is given, my lord. In the meantime, I will submit the report. And if he desires to file like
I claim for additional compensation which had passed on 2017.
এবার ঠিক আছে বলছি
হ্যাঁ, হ্যাঁ।
তুমি আমার যে চালু যখন সাবমিশন করবো
Let him come back.
Make it
State
short.
also, I do not, Mr. Ganguly is not there today. The Learned Counsel for the National Highways Authority of India seeks extension of time to submit the report in the form of affidavit as called for. Paragraph, let the matter appear under the same heading on 6th July.
But can it be shorter? Before 2 months, my lord, my direction has been given, my lord.
Short enough.
Number 40. 40, my lord, I beg to appeal for the petition.
Asking for time. On prayer of the state respondents, the matter is adjourned. Let the matter appear under the same heading on 7th July. On prayer of the state respondents, sir.
Number 41. Sir.
Yes, next.
Ma'am, for the petition. I have served all the parties not and delivered.
Yes,
I have served all the parties and delivered.
Mr. Bhattopak, your appeal.
Yes, ma'am. The respond number 9 and 10, private respond number 9 and 10, unauthorized construction upon the PWD land in front of the petitioner house.
PWD land.
Yes. At page 28, not kindly see.
Nine and 10 are served.
Yes, ma'am. Delivered. Page 15 and 16 of my period service. Page 28.
Page
Page 28 of my application.
28.
Assistant engineer, public works department, Kitchener subdivision. Page 28.
Yes, Mr. Bhattopak.
Yes, ma'am, that may be considered.
Affidavit of service. None appears for the private respondents despite service. The
Respondent number 5.
petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have raised unauthorized construction by encroaching upon a portion of PWD road adjoining his plot, thereby obstructing his egress and ingress. the petitioner submitted a representation in this regard before the concerned authority
Respondent number 5.
on 8th December.
Yes.
8th December 2022, which is yet to be considered. 7th December, 8th now. 7th December 2022, which is yet to be considered. Stop. The petitioner pays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the fifth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the fifth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of.
Can direct the demarcation. Can direct the respondent to demarcate the land. No.
The representation says so, and then the proceeding has to be started.
Yes.
Item number 42.
Yes.
Item number 42, I am for the petitioner. I am for the private respondent. I am filing exception.
Have you served?
Exception is state. State. We have received the exception yesterday evening. Yes, madam. Yesterday I've started. We need some time to deal with that.
Some time is required.
Kindly recollect this matter pertains to the Defense of India Act. Lordship last time extended the interim order, and it was adjourned at the behest of the state respondent.
Well, my case is Malad. It is not a acquired Malad Defense of India Act. Malad, a civil suit is pending Malad in subject matter of challenge Malad. And in that civil suit Malad, a report was filed Malad by the Block Land and Land Reform Structure. Kindly see Malad page 10 Malad, my exception.
So there is already an interim order till June 30th.
Yes.
So let the matter appear prior to that. Yes.
It is the DM report that it was acquired or required, whatever it may be, under the Act of Defense of India Act. Now, private respondents is disputing the report of the district magistrate.
You are for the private respondent.
I am for the writ petitioner.
I am for the
You are
private.
the private respondent.
Yes,
So you want to come back with an exception?
তোমার একটা exception আমি
আমি
দিয়েছি।
দিয়েছি তো কথা।
দিয়েছো?
হ্যাঁ,
কই?
আপনি দিয়েছি। আপনার
Reply.
কাছে
I want to come back with a reply because they have taken an exception to the report of the state.
আপনি রিপোর্ট দিয়েছিলেন, রিপোর্টের কথা থাকবে তো।
আমি তোমাকে জেরক্স করে দেবো, আমার কাছে নেই। আমাদের
This is an exception by the private respondent
Yes, Malad.
to the report of the state.
To the report of the state.
Yes. So what do you intend to file?
I'm going to file a reply because I'm going to file a reply to this,
To the exception?
to the exception, because your lordship so permits.
No, if it is necessary, if you want to file, you can. I can grant you
Because
liberty.
they are saying and now saying that they are disputing to the report of the district magistrate.
Malad, they are file a civil suit that is pending. On that civil suit, it was
That
filed.
is not at all germane to this case. But saying so,
Come back.
আমি জেরক্স করি।
A learned counsel for the petitioner
হ্যাঁ,
seeks to
তোমার ওটাও দিয়ে ওটা।
use an affidavit in reply to the exception used by the 11th respondent. Paragraph, let the matter appear under the same heading on 29th June.
Malad, 28 June.
29th.
Malad, that was Malad, that is perhaps that is the Malad holiday.
28th.
Malad 20.
Oh, ha.
Malad,
So 28.
kindly Malad, July Malad.
then the interim order will be
So in that case, the interim order has to be extended.
Well, kindly, মানে 8 my lord, it is like go to the ballot. But that's why
You want to come back in July?
50.
6th July?
Then kindly extend the interim order.
But 6th July. Paragraph, the interim order granted early, 6th July. Paragraph, the interim order granted earlier is extended till 31st July or until further orders, comma, whichever is earlier.
Number 46.
The 40th I am for the petitioner.
State, Mr. Bandyopadhyay. Yes.
But there was a short-term mining lease agreement with the petitioner. License, query permit, my lord. I was using that. I prayed for extension and for a long-term mining lease also. That was not considered a approach before this honorable court. This honorable court directed the authority to consider my representation and pass a reasoned order. That I have annexed. That was in 2014. Thereafter, my lord, nothing has happened. I given representation. Even then, that has not been considered.
The provision of
Why didn't you come up in contempt?
My lord,
Why?
consider whatever. Consider whatever.
Yes, so that was not considered, you say.
No, my lord.
So isn't it contempt?
Consider order, but these days, my lord, the consider order are not being challenged in a contempt proceeding. My lord, the contempt proceeding, they come with an affidavit that
You have set out a new rule for yourselves.
no, my lord, that I have given a representation that has not been considered.
So doesn't that amount to contempt?
But that is
There was a direction for consideration of the representation.
my lord.
The authority has not complied with
But
it.
kindly have a look at page 17, the earlier order passed by this honorable court, my lord. 17, my lord.
This was in 2014.
My lord.
Yes, Mr. Bandyopadhyay, 6 weeks from 2014 has not expired as yet. And this is a demand of justice made by you.
My lord.
It's a demand of justice made by you.
My lord. My lord, prior to that, my lord, I missed one thing, my lord. A notice of hearing was there, the next page, but that order has not been passed even. The 1911-2014 notice of hearing was there, hearing was conducted, but no order was passed.
Pursuant to the earlier order.
Pursuant to the earlier order, notice of hearing was there.
There at page 18.
Page 18, my lord, P4. No order has been passed yet. I request for the order. What is the fate of my application or what is the fate of the hearing? That has not been, my lord.
Hearing was done.
My lord.
Yes, Mr. Bandyopadhyay.
Well, if the proceedings, my lord, have been initiated and hearing has been taken, the order has not been done, let it be completed.
Let it be completed since 2014, my lord.
আমি তো জানা নেই, আমিও instruction ছাড়া বলতে পারবো না।
I have served it on earlier occasion.
Let this order be complied with within 2 weeks. You are waiting since 2014. Yes.
But if it is already not passed or communicated with the petitioner.
Let the order be complied with because he has not received a copy. The petitioner's grievance is that the order passed by a coordinate bench of this court on 6th August 2014 in WP 8465 within bracket W of 2014 has not been complied with by the concerned authority. Paragraph. The order dated 6th August 2014 is set out, page 17. Paragraph.
My lord, on 2nd of December, sorry for interruption, 2nd of December 2014, hearing was there, but the page 18 shows that.
18 is the Yes, yes.
2nd December.
Learned paragraph, learned counsel for the petitioner submits that pursuant to the said order, a notice of hearing was issued by the authority upon the petitioner on 19th November 2014 and hearing was held on 2nd December 2014. Stop. No further communication has been made to the petitioner till date. Paragraph. Upon consideration of the submission made on behalf of the parties, comma, this court is inclined to hold that since hearing was held in compliance with the order dated 6th August 2014 passed by this court, comma, the concerned authority be directed to communicate a copy of the order, a copy of the decision arrived at by the authority at the earliest. Paragraph. In view of the paragraph, the writ petition is accordingly disposed of, directing the ADM DLLRO.
ADM DLR. This was 3 months.
The third respondent.
Third respondent.
Directing the third respondent to communicate a copy of the order passed by him
Respondent
upon
number 4.
hearing.
Respondent number 4.
3 had issued the notice. Oh, 3 and 4 are the same persons.
ADM, my lord, only mentioned, my lord, the ADM and DLLR.
So 3 and 4 should be the same person, isn't it?
But there are so many ADM.
They will not kindly direct the
So it will be the fourth respondent.
Fourth respondent. It will be
Fourth
better.
respondent, third now. Fourth respondent, ki bolam, to communicate. Upon hearing the petitioner on 2nd December 2014, comma, within 2 weeks from the date of communication of this order. Disposed of.
Service be taken on the.
Sure, the affidavit says. Next.
Number 44.
My lord, I am on behalf of the petitioner, my lord. Today is the date fixed for filing supplementary affidavit with regard to certain relevant documents for the petitioner, but we have not completed the petition. Kindly give some more times, my lord, so that we can file the affidavit, supplementary affidavit.
Who is appearing for the respondents? You're appearing?
I am
sir?
for the state, my lord.
Let them come back. Please serve an advance copy.
Lordship, I'm on behalf of Mr. Talukdar for KMD.
You're not on behalf of Mr. Talukdar, you're on behalf of the KMD, isn't it?
And 10 to 15 days time is required, my lord. Kindly, 10 to 15 days time is required, my lord. Kindly.
My lord, this is the case, my lord, that in the deed of gift, he has, the petitioner interest has got only 1 decimal of land. Now he has gifted 3 decimals. That is the deed, registered deed.
No, my
Now, my
actually,
lord, what will, my lord, improve by the way of supplementary?
one previous application has been filed regarding the acquisition of land, but further, when the state report has given, it has been found that our land has not been acquired, my lord. And that is why lordship was directed to file a fresh writ petition regarding the demarcation and the segregation of the land, my lord. And that is why I was filing this application. And now, my lord, the some relevant documents is required for that.
Let her come back, let her come back. Learned counsel for the petitioners seeks extension of time to use the supplementary affidavit as intended. Paragraph, let the matter appear under the same heading on 14th July. 14th July.
Uh, 45.
45 Lordship, Mr. SUVRA is appearing for the addition of parties. We have filed a CAN application being CAN 1 of 2023 for addition of parties.
Served.
Yes, your Lordship, I have served.
Lordship, I am appearing for the private respondent 7 to 12, Lordship.
Petitioner,
Lordship,
received a copy?
Lordship, I'm praying, Lordship, kindly keep the matter at 2 p.m. Lordship, Mr.
Possible, sir. No passover is possible in this.
Lordship, kindly make it not today. Lordship, Mr. Ahmed is arguing a matter in court number 29, Lordship.
If your lordship kindly come to page 9 of the addition of party, their application,
your lordship will find they are the owner of plot number 1936 and 1937, page 9, paragraph 1.
Fantastic. No, understood.
Last occasion, your
Let me just find out if the application has come.
on last occasion, your lordship directed the state respondent to file their
A
report.
report, yes,
But I am applying for the private respondent 7 to 12, Lordship. Today I am filing Wala.
in the department. In the department.
Lordship, kindly allow me to serve the copy of petition, Lordship.
You have been served.
Lordship, but I have not received the copy, Lordship.
So you have refused to accept the notice. Please serve them a copy. Because he is appearing.
It has not been filed any report, my lord. Inspector.
Yes, Mr. Butterbuck.
In spite of our communication at the note from my lord,
So you're asking for some time? in the report?
Two occasions they failed me.
Please be ready on the next occasion.
Lordship, kindly direct them to serve the copy, Lordship.
But I am opposing the application for addition of party.
He is not moving it at all today, I think. You're asking for time.
Yes, your lordship. Mr. Hamath has all the instructions, lordship.
WPAT order. Learned Counsel for the state respondents seeks further extension of time to submit the report in the form of affidavit as intended. Paragraph, let the matter appear under the same heading along with Can 1 of 2023. On 10th July.
Lord, there is problem, my lord, if your lordship kindly fixed earlier, because my lord, the private respondent is constructing the boundary wall. My lord, within the acquired land, which is in front of my land.
No, Lordship,
This
this
is the
allegation is
fact.
false.
Otherwise,
No,
my lord,
Lordship, this
might grant me interim order by the state.
No, Lordship, this allegation is false.
construction.
Lordship, 144 matter pending on
Otherwise-
19 June.
We have filed
To
a
the
suit
SDM,
also,
to the SDM court, Lordship.
They are encroaching the land, lordship.
No, Lordship,
Pending on?
pending on SDM court, executive magistrate, barrack before barrack on 19 June, Lordship. On Lordship, London court direct all the concerned authority to appear on that day, Lordship.
We have filed a
Appearance.
suit, lordship.
You can make this submission before the SDM court also.
My lord, we have made, my lord, they are taking that order. Police has also been made party. By in view of that order, they are making construction. My lord, only one
Making construction is false allegation. Lordship, you have made no construction has been.
An order directing any boundary wall.
144, the executive magistrate has directed.
Lordship, I have the order. Kindly show the order, Lordship.
Boundary wall.
Yes, my lord, can you see that?
Please, Lordship, there is no boundary wall, Lordship.
Your
Do you
lordship,
have a copy of the order with you?
Yes, Lordship.
Please show
I have
me.
copy. Lordship, kindly see.
Come back on 30th June. 30. Yes?
Lordship, I have the copy. Lordship, kindly see the copy, Lordship. Order copy.
30th June.
Chill.
30. 30th June.
the top of the list, my lord.
Slap you. It's being called.
Lordship, kindly, Lordship,
Please show me your order.
kindly submit I am appealing on.
Copy to the, copy to the.
Give your name.
Requirement is on.
What is the order? You say it's recorded as the said order. Which is the said order? There is some order before this?
19 June.
Yes?
Matter is fixed on 19 June.
Where is the order that is referred to in this petition, in this order?
For this reason, my lord, I am praying for interim order. By showing
No,
that
Lordship.
order by the police authority, they are coming and making construction.
No, Lordship, making cause is false.
Come back on 30th. It's a short date.
Your lordship also directed the state authority to submit the report.
Yes.
Group 7 motion item number 95.
In this matter, Mr. Manish was appearing on behalf of the petitioner.
Yes,
Manish Susila is appearing the petitioner.
Yes.
He requested to what telephone to prefer adjournment or a day. I don't know the application.
Application.
on prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading. On 4th July.
Number 96.
And for the petition led by Mr. Chaudhary. While at the last occasion, your lordship had directed the state to file a supplementary affidavit.
Well,
Please-
time given to file the supplementary is ready, but affirmative officer is engaged in other.
Learned counsel for the state respondents seeks extension of time to use the supplementary affidavit as intended. As intended, huh? Paragraph, let the matter appear under the same heading. On 5th July.
Number 97.
I'm led by Mr. S.L. Mukherjee.
Take the microphone, please.
In this matter, I'm led by Mr. S.L. Mukherjee. Here, in this matter, it's a long pending matter where subject matter of challenge is the order which appeared on page 36, your lordship. Wherein, your lordship, the question of additional vehicle is there, which has been allowed. Then a hearing was taken place, then it was rejected. And I'm challenging this order, madam, which appears at page 36, madam. Your lordship, on last conference, your lordship directed the state respondent to take
Further instructions.
Further instruction, your
My lord, I have taken instruction, lordship. My specific instruction is this, my lord, let the issue be reheard by the secretary once again, where, my lord, all subsequent developments and, my lord, exchanges and, my lord, the letters, the exchange between the two states could be produced, and this can be, the issue can be, my lord, resolved in presence of the parties.
Because the notification that you have relied upon has
Yes.
not been finalized.
I am also told, my lord, on the basis of that, for few years, the going on in the same way.
The draft notification.
That was the issue. So, my lord, if that be so, at the time when this, my lord, certificate was issued or this, all the permissions were granted, the same, my lord, that they accepted. Now they have taken the plea, but subsequently, my lord, what are the developments in number of years, my lord, that could be resolved by showing papers and hearing them. I believe, my lord, without making the keeping the matter pending, let the secretary rehear the matter issue once again. This is my humble submission, lordship. Otherwise, my lord, all of documents, bring that document, they are also in a position. Let me not the considered in with all these papers in their presence. Issue is very short, so that will be clarified, lordship. Let the issue be reheard by.
Now, can you see page 32? At the bottom, left hand side.
Yes.
This was allowed to. It is not the case. It's the first time. But after replacement, they are saying all this. When I got the replacement from the original granting authority, now I place that vehicle, then they are saying no. So let this see, your lordship will find the page 32 that they have allowed.
Not denied. I am saying that since 2007 notification, based on that, my lord, at
Mr.
least
Naik says that let
15
this be
years.
set aside. Let the authority reconsider upon hearing you.
lordship, and all the paper they can examine, and my lord, it will be there will
Yes.
be a logical conclusion.
That will logical
memo
conclusion,
will
Lordship.
be- Memo impugned to be set aside.
Not set aside.
Page 36 will be set aside.
My lord, what-
How can it be
what-
reconsidered?
No,
What-
if there is the considerations comes only after lordship satisfied that this is wrong.
Very well.
That it has
Then
to
the
be set
reasons
aside.
has to be given. I say, my lord, for the timing, it may be kept in abeyance.
It will be set aside.
Lordship.
The order passed by the,
No.
this is Deputy Secretary. Who passed the order?
Yes.
The Deputy Secretary, State Transport Authority, West Bengal.
Deputy Secretary, Lordship. Let him
But that
consider
is
1
also
second here.
one of That's also one of the issue I have taken here.
Take the point before that.
Recalling the endorsement of additional vehicle and modified timetable for cancellation of the same passed on 26th December 2019 is assailed in the writ petition. Stop. Paragraph, learned counsel for the petitioner submits that the said order has been that the said order is based on the said order has been passed on the anvil of a notification issued on August 30, 2007, which is in fact a proposed a notification issued on August 32, 2007, comma, the amendments wherein the amendments sought to be made are only proposed amendments and have not been finalized. Stop. According to learned counsel, comma, the State Transport Authority, West Bengal, which granted counter signature in favor of both the vehicles of the petitioner earlier, comma, could not have both the vehicles of the petitioner earlier could not have recalled the same on the basis of amendments which have not been finalized at all. Paragraph, learned counsel for the respondents candidly submits that the concerned authority be directed to reconsider the request of the petitioner upon hearing the petitioner comma, in accordance with law. Paragraph, in view of the above, comma, this court is inclined to hold that since the order impugned relies upon an amended provision of the notification issued on August 30, 2007, which is yet to be finalized, comma, the order requires to be set aside. Paragraph, accordingly, the order impugned passed on 26 December 2019 by the Deputy Secretary, State Transport Authority, comma, West Bengal is set aside. Paragraph, the concerned authority being the respondent number. Being the second respondent herein, comma, is directed to reconsider the request Let it be four. Let it be fourth respondent code. Ki bolam last. And pass a speaking and reasoned order upon affording reasonable opportunity of hearing to the petitioner, comma, in accordance with law. Paragraph, the decision taken by law, reasoned order bollam, within 1 month. ওখানে pass a reasoned order within 6 weeks from the date of communication of this order upon affording reasonable opportunity. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereafter. Disposed of.
$98.
Please switch on the microphone.
Yes.
Please switch it on.
File my supplementary ABDB. That is not file, I think so.
No, I could not file my supplementary affidavit, but so far as the contention of the respondent was that payment has to be up to date. I have taken instruction. I am making payment.
No, my lord. That is
Now the only contention is this, my lord. Lordship
false
will remember.
statement, my lord.
No, this is not. I have
Statement. Your lordship, can you
want
see
to
that
submit the
statement?
supplementary affidavit?
Lordship, I
As
could not
per
able to
license
file
fees
it
concerned,
because
can you see that statement, my lord?
that is their statement, my
But
lord.
only
That's the
50%.
reason why you wanted to file your supplementary affidavit.
Yes.
Yes, my lord. Probably
50% paid, my lord. Out of 38 lakhs.
Probably, my lord, my learned friend is not addressing lordship the perfect. The issue is that regard to these 5 catering stalls which have been installed pursuant to the tender floated by the railways, my lord. I have started my business in the year 2021 itself because spaces were not made available. There were no water connection, electricity connection. Lord, he remembers that
That is
matter.
not the issue. On the last occasion, my lord,
Yeah,
you
and
must
let
have directed the petitioner to paid manner all the license fee.
may I
That is not
complete my
paid, my lord.
submission?
That
Let
is
me
long submission on the part of petitioner, my lord, that they have been paid all the amount, my lord. But at present time, according to my instruction, my lord, that is not paid fully, my lord. Without license fee, how can it
let
be?
me
How
complete
can
my
it be a mental
submission. This
level,
is
my
my
lord?
application after all.
I think you have
That
to
is true.
come back with the supplementary affidavit.
Then in that case, my lord, my
with your
respectful
submission.
submission is only this. The issue is in the present writ application is the commencement of the work, which shall be commenced, whether my date, which has been approved by the railways, that should be treated as a commencement date, or the impugned speaking order, which I have assailed in the writ application, where they state that 20th of March 2020, the day the lockdown start, that will be treated as a commencement date. From the reply and from the report which appears and that which has been placed before your lordship, they have stated in no uncertain term that the commencement date is the date from where I have started my business. They have accepted that. And now whatever the license fees I have paid, that is on the basis of the commencement date of 2021. Now what my learned friend is saying, I have taken instruction, I will put it in an affidavit.
That can be
Let-
filed with
let-
affidavit, my lord. Without affidavit, how
Now,
can
my contention is this, that they have calculated the license fee from the year 2020 itself, when there was no business, no stalls could have been erected because no space was made available. It has been accepted by them in the opposition that space could not be made available. So they are counting license fee from that period when there was no work. I calculated the amount and I paid the amount, and that they have accepted it. Lordship, that I will put it in my affidavit as per the commencement date, that is 2021, and not for as the date where there was no business.
So
As
please give the entire calculation also.
I will provide with
Yes,
the entire calculation.
Without
Lordship, today we are
affidavit,
standing on Lordship
only
13th.
verbal
Lordship,
submission, my lord.
give me at least 14 days time or 10 days time at the most. I will come up with a supplementary affidavit because interim order is there till 30th of this month.
That is long time.
So come back on 29th.
Yes, I will come back on 29th. By that time, I will file my supplementary affidavit.
Please serve an advance copy.
I will serve
So
an
that we
advance
can
copy.
deal with the matter
Yes,
on the
my
next. Learned counsel for the petitioner seeks extension of time to use the supplementary affidavit as intended. Paragraph, let the matter appear under the same heading on 29th June.
98 to 102, my lord. Similar
Take
matter.
that yours. 98 to
102. Same.
98 to 102, same order.
Copy.
Hundred and three.
103. The response number 12 and 13. This matter hearing on behalf of the petitioner. Now, in this case, my lord, I am holding a permanent interstate permit on the road, page number 16. Page number 16. My lord, serial number 7. Route is Puri to Holdia, interstate route. In terms of reciprocal agreement in between the state of West Bengal, state of Odisha, this permit was issued on the route Puri to Holdia. This permit was valid till 15th January 2024. Serial number 8.
Yes.
And also, my lord, this time tool was issued and also counter signature by the state of West Bengal because permit issued by the state of Odisha. Now, my lord, I have been read the objection against the private respondent.
Take the microphone.
Page number 21.
Microphone.
Page number 21. Page number 21. The respondent number 12, private respondent number 12, operating their vehicle, her vehicle on the route Ghatal to Bhubaneswar. Ghatal to Bhubaneswar. This state Odisha countersigned this permit. And on next page number 22 is the timetable that has been countersigned by the state of Odisha. This permit was issued by the state of West Bengal. My lord, Ghatal to Bhubaneswar. And the response number 13, page number 23. This permit also issued in favor of the response number 12, Sompasi, on the same route, Ghatal to Bhubaneswar. I made the objection that response number 12 and 30 are not completing the inter-alignment of the road. Their route is Ghatal to Bhubaneswar, flying from Bhubaneswar to Nandakumar. From Nandakumar to Ghatal, that is more than 100 kilometers. The based on 12 and 13 and not flying the vehicle. So I made the objection, violation of permit condition, because I am the valid permit holder, because my permit is also, my route is also covered. So I have right to raise the objection against the illegality. So I made the objection with page number 25. Page number 25. I made the objection before the Secretary of State Transport of Odisha as well as Secretary of State of West Bengal. But that objection has not been considered in the pending. So direct the Malord response number. Respondent number 2, respondent number 2, that is Secretary of State West Bengal. 3 secretary. 3. This one 2. Yes. I'm for the respondent number 12 and 13.
That's all your submission, Mr. Khan?
Yes.
Yes.
But what happened, my lord, in terms of this objection, my lord, the State Transport Authority West Bengal conducted a hearing
but my learned friend, all his client did choose to appear.
No, we have not received. After hearing. we
Then
have received.
whether this objection is still pending or not, I do not know. Your lordship
Pending.
direct,
No
if
decision
it
has
is
been taken.
pending.
No decision has been taken. But my landlord will appear on behalf of the state. He cannot give the answer. No hearing has been taken.
That's all your submission?
I appear and Mr. Khan, Akhtar also.
Yes, Mr. Devra?
আমরা ছিলাম আমাদের চিঠি দেয়নি
Lordship kindly see the letter, notice.
ডিসিশন নেই আমাদের ছিলাম
ঠিক আছে। If
we are not
if the objection is pending,
hearing got postponed.
if the objection is pending,
If it is pending, if not already decided, let it be
Yes,
decided.
yes,
Yes?
yes.
The petitioner
আমাদের নাম
claims to be holder of a stage carriage permit in the interstate route Puri to Holdia via Joleshwar, which is valid till 15th January 2024. Stop. The private respondents were granted permit by the State Transport Authority, West Bengal, in the route Ghatal to Bhubaneswar, via Tarakeshwar, Bajkul BAJKUL, Cuttack and back. Stop. The petitioner alleges that the private respondents are not plying their respective vehicles in the entire route and are plying in the route Nandakumar to Bhubaneswar. In the route Nandakumar to Bhubaneswar, which is not authorized in the permits,
That is
in
the
violation of the conditions of the permits issued in their favor. Stop. The petitioner submitted a representation in this regard before the concerned authority on
2nd September.
Submitted an objection, representation, an objection with on
2nd September, page number 25.
Page number 35.
It's 1st September, but this is not 2nd September.
It was made on 1st September.
Page number 25.
On 1st September 2022, which is yet to be considered. Stop. The petitioner prays for consideration of the said objection at the earliest. Paragraph, it is submitted on behalf of the private respondents that pursuant to the objection filed by the petitioner, a notice of hearing was issued by the concerned authority, and though the private respondents were represented before the authority on the date of hearing, none turned up for the petitioner hearing. Learned Counsel submits that the hearing may have been concluded on the relevant date. Paragraph, it is submitted on behalf of the state respondents that the second respondent be directed to
State Transport Authority.
consider and dispose of the objection submitted by the petitioner comma, if not already disposed of, comma, in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioner dated such and such, comma, if not already disposed of, comma, within 1 month
1 month.
from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of, effect. 1 month.
Lordship, make it 6 weeks. Well, election is coming.
You are the private respondent, sir. The state has no objection.
See, it's the 1 month.
It is strange that the private respondent is asking for extension of time, not the state. Rajiv, 6 weeks. Next.
And then for. Lordship, I am for the petitioner in this matter, your lordship. What has happened in this matter? I am a manufacturer of e-rickshaw. As it knows that Toto, the state go, the respondent number 7 on a purported plea that this is, I have already the exception, your lordship. May be permitted to file the exception. What has happened on 1st of February, without any rhyme and reason, my factory at Raiganj, because I am having factory in many parts of West Bengal, at Raiganj been seized on a plea that I am an illegal manufacturer. That was what transpires from the report. And at that point of time, I was not having the TCR. TCR is the document which is required for the dealer to keep the car for registration. Being a manufacturer, I am not required to have the TCR. Now, your lordship, they are admitting that I am a approved manufacturer of e-rickshaw. Then also, they are not removing the padlock, and I am not being able to function or manufacture the e-rickshaws. Lordship, kindly hand over. I am just giving the list published by the director. At second page, your lordship will find at item number 27. They themselves are saying that this is a list of the approved manufacturer of e-rickshaw. Now, being approved manufacturer, they are still not removing the padlock. My factory at Raiganj is under the lock and key. And what has happened on a purported direction, which is not applicable for me, it will come up in the report. Your lordship will be kind enough to take page R2 of their report at page 10. Your lordship will see. May I place your lordship? Page 10. Page 10 of their report.
Yes.
The second paragraph. You are now requested to lodge FIR and other legal action against those unauthorized manufacturer. Your lordship, this is not at all applicable to me. Based on this, it's an absolutely misconception, because they themselves are saying that I am a approved manufacturer and FIR has been lodged. I'm not on the quashing of the FIR. I am only on the arbitrary action of seizing my factory. From 1st of February, my factory is lying closed. I do not know what has happened to the batteries and other things, because I am not been able to gain access to the factory. And your lordship will kindly also take their exception. They are admitted in their exception that right now I am a authorized legal manufacturer. But at that point of time, I was not been able to produce the TCR, which actually not applicable to me also, because it is applicable only to the dealers. Being a manufacturer, I do not have to produce the TCR. Lordship, kindly take page 6 of the report, your lordship.
Give me a minute, please.
that further to the aforesaid, it is learned that the permission was granted in favor of the writ petitioner by the respective authority. As your lordship got it here.
Yes,
Paragraph 6, your lordship. Page 6, paragraph 6.
subsequent to the rate program, they say.
So right now I am having the, prior to that, in the month of January, approached this honorable court asking for registration. At that point of time, they have also not raised that I am an illegal manufacturer. They said that, and the order was passed. Subsequently, I have been ordered was passed that I am a manufacturer. But till now, they are not opening my factory and padlock. And your lordship, I made a representation. That representation at page 8 of the report has been rejected by them, saying that the same thing, that TCR was not there. And though I am a manufacturer, but at that point of time, the TCR was not there. So the my request of opening the padlock cannot be adhered to, and it's remain on the season.
That's your piece. Yes.
Your lordship kindly takes my report, my lord. Kindly takes my report, my lord. My lord, may I place, my lord, from page 3, my lord, paragraph III onwards. Has your lordship got it, my lord?
Yes.
That the Transport Department, State of West Bengal, in terms of memo number such and such, they issued instructions of all the district magistrates and regional transport officers throughout the state of West Bengal in Delhi to keep a strong vigil and to report thereafter as regards the supervision and inspection carried on with regard to illegal manufacturing vehicles, especially totos in the districts, and pursuant thereto the rate programs have been carried out on time to time by the undersigned, which results in the identification of the illegal manufacturing of toto carried out by the writ petitioner in the Raniganj area, and consequent thereupon in ensuring true compliance with government order as referred to have FIRs in the local police station have been lodged. But this is the instruction of the government of West Bengal, my lord. Thereafter, my lord, paragraph 4, Roman 4, that in the line of the aforementioned paragraph, the photocopy of the complaints lodged by the RTO Paschim Midnapur before the local police station at Raiganj against unauthorized maneuver of non-approved e-rickshaws is annexed here to Market Annex R3. Your lordship kindly takes R3. This is the letter of complaint by the, my lord, concerned RTO. I such and such, I have organized a rate program on 1st February 2023 at about 3:30 p.m. against unauthorized manufacturing of non-approved e-rickshaws at offshore enterprise situated at such and such place for manufacturing non-approved e-rickshaws in compliance of the order of the Transport Directorate, Government of West Bengal, by memo number such and such. During rate program, a few members of unauthorized e-rickshaws found inside the premises of offshore enterprise and also found a manufacturing unit of unauthorized e-rickshaws. Accordingly, our team sealed the premises and manufacturing unit in presence of such and such. Under the circumstances, I request you lodge an FIR. This is the, my lord, FIR. And thereafter, your lordship kindly takes, my lord, page 5 of my report, my lord, Roman 5.
Page Roman 5.
Page 5, paragraph Roman 5.
Yes.
It's hereby again reiterated that it is thoroughly outlined in the government orders issued from time to time by the state of West Bengal that illegal selling, manufacturing and plying of e-rickshaws shall be strictly dealt with by all the authorities who or which are subordinate to the Transport Department, State of West Bengal, and as such, on the 1st day of February 2023, the rate program was carried out by the RTO concerned, along with the officers and staff providing due assistance to the said officer. Since no permission on the day of the raid was there unto favor of the writ petitioner, my lord, I am, my lord, giving importance in this line, my lord. Since no permission on the day of raid was there unto favor of the writ petitioner, hence the manufacturing and acts incidental thereto have been considered as illegal by the officers conducting the raid. And therefore, the available materials were seized, followed by sealing of the manufacturing center possessed by the writ petitioner in presence of deputy magistrate, and keeping in mind the fact that the TCR is one of the vital documents which would justify in preventing the officers carrying out any raid program, as well as the registering authority vested with concerned officer for registration of vehicles against stealing of any manufacturing of e-rickshaws. And since the said documents was not available with the writ petitioner on the day of carrying the raid program, hence the plea or request made by him for vacating the steps taken so far in relation to sealing the e-rickshaw manufacturing center does not and cannot arise, and simultaneously does not have any legs to stand. Hence, in terms of the representation dated such and such, the request made by the writ petitioner was not plausible to be acceded to by the office of the undersigned. Paragraph 6. It is learned that permission was granted in favor of the writ petitioner by the respective authority subsequent to the raid program carried out by the undersigned. And as on the day being fixed for continuing the raid, the documents like TCR was warranted was not being available in the writ petitioner's possession. Hence, the sealing of the manufacturing center was given effect to. That all the abandonment contested by the petitioner has been considered as such. It is established that unless specific demarcation like exhaustive guideline regarding issuing permission to manufacturing e-rickshaws would be declared by the competent authority, it is hardly plausible, my lord. This is the, my lord, the reason for, my lord, sealing of his unit, my lord. Absolutely illegal, my lord. On the day of the raid, he could not produce, my lord, the SI permission, and with the, my lord, which is vital, my lord.
So subsequently, manufacturing permission was accorded.
Subsequently.
So as on date,
At the time of raid, he could not produce any permission letter.
so as on date, they have a manufacturing document.
Yes, your lordship, I handed over the list, your lordship.
Lordship, my lord. Because paragraphs, Roman 6 is clear. Subsequent to the raid program, it is that the permission was granted in favor of the petitioner by the respective respondent, respective authority, subsequent to the raid program carried out.
Yes, so as on date, they have a
As on date, they,
manufacturing
yes,
permission.
yes,
So you cannot call them unauthorized as on date.
yes. Because at the time of raid, he could not produce it. At the time of raid, he could not produce.
Now that he is able to produce it,
Yes,
you have to take a decision.
yes, we will take a decision.
Lordship, it has already been rejected by him, unless that's been set aside. And your lordship, the list of manufacturers.
Kindly sees the reason. Kindly sees the reason, my lord, page 8, annexure.
They did not have a document on the date of raid.
Lordship, my lord.
That is the only reason.
Lordship, they are saying not, I'm having the TCR. TCR is not required for the manufacturer. It is required only for the dealer. TCR, not a single manufacturer requires a TCR. I'm just giving an example to your lordship. Suppose Bajaj is producing the cars. Bajaj do not require a TCR. The dealer of Bajaj require a TCR to display those vehicle and for sending those vehicles to the registering authority for registration purpose. TCR is not a document which is required by the manufacturer. It is only required by the dealer.
Lord, according to us, it is required. My lord, it's very vital and mandatory. That's why, my lord, that
Show
is.
me the rules. The Motor Vehicles Act.
Rule
the
35, your lordship.
West Bengal rules.
Central, motor vehicle central.
এটা বার করে দাও।
$335.
35, your lordship.
35. Is both for the dealer and the manufacturer.
Yes.
35.
Lordship, 36 trade certificate, if your lordship kindly see.
36 refund.
An application for grant of renewal or trade license shall be made 34, your lordship.
Grant of renewal. That's a, which form it would be submitted, that has been described.
Yes. So this doesn't come to your aid.
Lordship, whatever it might be, I am the
We're
manufacturer.
supposed to be in possession of a TCR on the relevant
Yes.
date.
But generally speaking, this is the trade practice, your lordship, that TCR is required by the dealers.
Irrelevant.
I bow down. I bow down.
Because 35
I
very
bow down, but
specifically says, isn't it?
but this is the general trade practice what I'm talking about.
You can file, if you want to file a further representation, since you are in possession of the approval at the moment.
Lordship, then that order be set aside, your lordship. Otherwise,
Right
that
now,
will,
I do
that,
not find anything wrong in the order.
Lordship, my lord.
lordship, but he's saying that I am having the approved manufacturer right
He
now.
says on the date of raid, you did not possess a TCR.
Yes.
That is sufficient ground for sealing your unit. So if there's a change, in circumstance, you might as well approach the authority with a fresh representation
Lordship, pass an order for filing a fresh
or
representation.
change of circumstance. Let the
Yes.
authority consider it.
My lord, at that
Yes.
material point of time, my lord, he could not produce, my lord,
You
requisite
have
document.
stated that. That is admitted.
Yes,
Now that he has the document in his favor,
yes.
let him come before, approach the authority with a fresh representation. Let the authority consider. Let him file the relevant documents. This is a change of circumstance.
The lordship will be kind enough to make it clear that this is a change of circumstances is there. Otherwise,
Then your lordship kindly, it will, my lord, says, records that our action is absolutely legal, my lord.
You have a prayer to that effect?
No, my lord, but your lordship held, my lord.
I'm not setting aside your order. It is written.
Justified, it is justified, your
I'll
lordship
record.
kindly.
I'll report in the form of affidavit submitted on behalf of the respondents and exception used by the petitioner to the said report are taken on record. The petitioner claims to be a registered manufacturer of e-rickshaws and has alleged that the respondent authorities have sealed SEALED his manufacturing cum sales office on 1st February 2023 on the allegation of unauthorized manufacturing of e-rickshaws therein. Stop. This was done by an order passed on.
Read petition ta Read petition ta
The petitioner submitted a representation ventilating his grievance before the concerned authority on 8th February 2023, which was considered and turned down by the authority by an order passed on 10th March 2023.
ওখানে যাও ও গঙ্গা প্রসাদ কোর্টে ঢোকান
On the ground, What is the document? The document for registration of vehicles was not with you.
Lordship,
The document for registration of vehicles was not with you on the date
no,
of
the
raid.
TCR, they are asking the TCR, temporary registration certificate for the vehicle.
My lord, your lordship kindly takes page 8. Page 8 of my report.
Yes.
From the bottom, last 5 lines. Last 6 lines, my lord. My lord, followed by the officers conducting the raid, and therefore the available materials were seized.
Now, what is the full form of this TCR? Temporary?
Registration certificate.
Temporary certificate of
For
registration.
registration, certificate.
No registration.
Well, on the ground that the temporary certificate for registration of the vehicles manufactured by the petitioner was not in possession of the petitioners on the date of raid of the unit. The order demonstrates that permission was granted in favor of the petitioner by the respective authority subsequent to the raid program carried out by the authority. Stop. The manufacturing unit of the petitioner was sealed since the petitioner was unable to produce the TCR before the authority at the relevant time. Stop. Paragraph, it is not in dispute that the relevant approval has been accorded in favor of the petitioner by the authority subsequent to the raid. Stop. In view of such change in circumstances, comma, the petitioner seeks liberty to approach the authority by a fresh application for removing the seal.
Yes, your lordship.
For removing the
Seal and carry out.
seal
And carry out the manufacturing process over there.
removing the seal and padlock of the unit of the petitioner in order to enable the petitioner to carry on the manufacturing business. Paragraph. It is submitted on behalf of the respondents. Who should we consider?
Respondent number 7, I think your lordship.
The
Subject to
regional
what calls
transport?
from my
That
learned
is-
friend.
Seventh respondent?
Lordship.
Seven?
7.
That the seventh respondent be directed to consider the representation of the petitioner in accordance with law. Paragraph, in view of the above, the writ petition is disposed of directly.
Lordship, time limit were given otherwise.
Absolutely. Disposed of with liberty to the petitioner to submit a fresh comprehensive representation before the seventh respondent within 7 days.
Yes, your lordship.
Within 7 days from date. The seventh respondent is directed to consider and dispose of the representation within 4 weeks.
Lordship.
Within 4 weeks from the date of receipt. The unit is sealed. Can it be 2 weeks?
No, 4 weeks. What is problem for me?
3 weeks.
Lordship.
Within 3 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to the petitioner and taking into consideration the change of circumstance to be put forward by the petitioner in the representation. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of.
Grateful to your lordship. Lordship, my exception we kept on record. I filed.
It's taken on it.
105.
No allegation against Mr. Devrai.
Yes.
Yes.
Mr. Sivra.
No allegations against Mr. Devrai. My client have been issued permit by the State Transport Authority West Bengal. It's an interstate route. Well, it's earlier issued, then it has been the Lordship will find at page 13 permit. It was issued way back in 2007.
Lordship, I would like to submit, Lordship, I have not been served with a copy of the petition in this, Lordship.
Affidavit of service says. Yes, the affidavit of, they have received it, my lord.
Please give her.
Well, that I am handing
It
over.
has not come to her from.
My lord, I am. Hey, extra copy.
It has not been communicated from Jharkhand, so give her a copy.
Did it. No, nothing is there. The permit issued in 2007. Way back. Now, this is from route from Bolpur to Dumka. That your lordship will find. Page 13. Now, it has been extended.
Page 13, 1-3.
1-3.
Yes.
Serial number 7, route Bolpur to Dumka. As your lordship got it. Then it has been extended. That is at page 20, 19 and then 20. Page 19. It was Bolpur to Dumka, then extended up to Atkhala from Bolpur. From Bolpur point to, it is within the state of Bengal. Now, then the State Transport Authority West Bengal wrote to the Secretary State Transport Authority Jharkhand. That is at page 21. And earlier they have renewed the counter signature. So they again, after renewal of the extension and the permit, it was renewed up to 2027 by the State Transport Authority West Bengal. Now the counter signature has not been yet granted, though it has been wrote to the Secretary State Transport Authority Jharkhand. The later dated 26th of September 2022.
Yes.
I also made an application. This is required, along with the fees. That your lordship will find at page. Yes, your lordship will find at page 22. This is my online applications and the permit type and the fees detail. Yes.
Yes.
Yes. Key 23 and your lordship will find the date. That is at page 23. That is also September 27, 2022.
Yes.
No steps. The vehicle is standing because it's a renewed permit already.
Let the Jharkhand Authority.
Lordship, I'll take instructions in this. Your Lordship,
Since
whether this has been placed in the meeting
since
or
September
as your Lordship.
2022, my vehicle is not operating in the state of Jharkhand. At least nowhere is operating because of the effects until if I full route, then I have to charge.
Mr. Mukherjee, let her come back with instructions because we do not know why it has not been issued.
Lordship.
There may be some reason for it.
Regarding my part is concerned, I
have. Yes.
My part is over.
No allegations against Mr. Devrai's client.
Mr. Mukherjee started with the sentence, no allegation against Mr. Devrai. So please come back with instructions.
Lordship, I'll get.
Affidavit of service. Paragraph is contended on behalf of the petitioner. Petitioners. That. That the petitioner is a holder of a permanent stage carriage permit in the route Bolpur to Dumka, which was subsequently extended up to Atkule, Atkule from Bolpur. Stop. The permit is valid up to 31st August 2027. Stop. The regional transport officer, State Transport Authority West Bengal, comma, by a letter issued on 26th September 2022, requested the Secretary, State Transport Authority, Jharkhand, to issue counter signature to the renewed permit of the petitioner upon realization of motor vehicles, taxes and fees as applicable. Stop. Such application has also been made by the petitioner online along with prescribed fees for the same. Stop. The State Transport Authority, Jharkhand, has not made any communication to the petitioner till date with regard to issuance of counter signature. Stop. Paragraph. Learned Counsel for the State Transport Authority, Jharkhand, being respondent numbers 3, 4, 5, and 6 herein, seeks to take instructions in this regard. Paragraph. Let the matter appear under the same heading on end of this month, 27 June.
Obliged.
106.
Lord, I am appearing on behalf of the petitioner, my lord.
Have you served?
Yes, office has been solved.
Mr. Debra is appearing.
Yes, this is a matter of extension of route. My lord, kindly come to page 20.
Third respondent, there was a direction.
Yes,
Jharkhand is also
You
appearing.
are appearing?
Yes.
My lord, may I proceed? My lord, please come to page number 22, please.
22.
Yes, my lord. Permit was issued on behalf of for the petitioner from the route Tata to Badabazar via Katin, and it was extended till Badabazar up to Balarampur by chairman on such and such dated 6th August 2019. It is written beside that only.
25th June 2019.
I'm sorry, man. And then a timetable was also issued, and then a letter was issued to the STA West Bengal on page number 24, my lord, by STA Jharkhand for countersigning the same.
Yes.
On page number 25, page number 25 in the bottom, it is written, it is therefore requested to offer your consent / necessary amendment and correction may be kindly made in your official record. Page number 25 at the bottom. Jharkhand requested West Bengal to countersign, but then after, on 13th August 2019, the petitioner has made a representation. Thereafter, paid the prescribed fees for the extension. And after that, 31st December 2020.
Counter signature was given for provisionally for 2 months.
Provisionally for 2 months. And the extension was only for 18 kilometers, not excluding 24 kilometers, as per the agreement, my lord. 5 kilometers was in West Bengal. It was extended to 18 kilometers.
That is admitted.
Yes. Yes.
Yes. What
But
is your grievance?
grievance is kindly come to page 32, my lord.
Yes.
In respect of my representations and all, the STA West Bengal has rejected the extension in the third paragraph, my lord, said that the said extension was not countersigned due to the violation of clause 2H of reciprocating transport agreement 2004, as the proposed extension falls in reciprocating state, that is state of West Bengal.
This was kept pending.
No, no, no.
This is not a final decision.
No, man. Then please come to page. Then again, I have made a legal notice, page number 33.
Why legal notice? Page 32 is not a complete order.
No, no, no. For
The matter was
putting in the next, for
next
putting in next meeting, page number 33. Then
So this
page
is
number,
not conclusive order.
page number 34, my lord. This is another meeting held, dated 24th August 2021. In the next page, page number 35.
Yes.
Again, at the bottom, the decision taken in the meeting, member of STA observed that no consent was accorded from STA West Bengal before allowing the extension of the terminal point from Barabazar to Balarampur by STA Jharkhand. As such, member of STA decided not to allow the counter signature of the said extension. Though the STA Jharkhand has prayed for consent to STA West Bengal, they haven't given any reply to that consent, and they have decided in the board meeting. Again, I have made a representation dated 28th July 2022
That's a demand of justice.
for demand of justice for consideration, my lord. On page number 38, the letter of the member of Legislative Assembly recommending the extension to the STA West Bengal was also annexed here. Well, he is a people's representative.
So,
He is recommending on behalf of the people. Then again on page number 39, agenda number 11, meeting dated 27 November 2020. They have allowed same issue upon direction of this honorable court, wherein the when the permit issuing state has approved the extension and they have not countersigned, they have allowed that. Again on page number 41, they have also allowed that, the same, on this same issue.
that's all.
Yes, my humble submission before your lordship is that kindly direct the STA West Bengal to consider the same on the basis of, because they have already allowed that in the previous occasions upon the direction of this honorable court.
Yes, Mr. Debra. Microphone, please.
On allegation regarding non-granting the counter signature, that no consent was accorded from the ST West Bengal before allowing the extension. Well, the portion is sought for, which is totally in West Bengal. Yes, prior to that, he has to take consent. The STA Jharkhand has to take consent from the STA West Bengal. Thereafter, they can allow. Sumoto, they allowed the extension. That cannot be permissible.
So it is an emotional tussle between the two authorities.
Emotional, my lord, this is the technique. Yes, my lord. Lordship kindly see, my lord. They has to.
Where is the provision for taking prior
This
consent?
is the, my lord, Lordship kindly see the clause 2H of the agreement, reciprocal transport agreement.
Is it annexed to the?
That has
petition?
not been annexed. Transport agreement is this. Achha, they- hearing নেই কোনো ব্যাপার না।
Clause 2H.
QH.
This is subject to prior consent.
But in the previous occasion, they've already allowed this type of issues. I've already annexed the orders, my lord. In page number 43,
You
44.
say there was no prior consent in that.
But after issuing
matters?
extending the permit, they have applied for consent. They haven't given any hit to that consent, my
They are
lord.
binding by the agreement.
Jharkhand had issued one notice for consent, but they haven't replied to that.
Where is your issue notice for consent? Prior to
Not
extending
prior
the
to,
route,
but after. But
the agreement is very clear, isn't
in
it?
this, in between previous
Says prior to
occasions,
The route, the extension.
but my lord, it is within the limit of 24 kilometers, my lord.
That is the
It can
another
be
aspect.
considered, my lord.
That
It's
is
within the
another
limit of
aspect.
24 kilometers.
Can be extended within 24 kilometers?
Yes.
With prior consent.
Yes, my lord.
So where is that prior consent?
But in previous occasions, they have already allowed this upon direction of this honorable court, my lord.
You have a representation pending?
Yes, my lord.
That's a demand of justice, sir, not a representation.
No, my lord. No representation is pending, my.
Will you file a fresh representation before the authority?
Yes, my lord.
I
Upon.
direct the authority to consider,
Yes, my lord.
Mr. Devra.
That is. But without touching the impugned order, my lord. Impugned order is absolutely correct.
So this is a subsequent representation.
Subsequent.
Please advise your authority to deal with it sympathetically. Because two other
That has-
applications have been allowed earlier. Same footing.
That is true.
You have nothing to add in this matter because you have already allowed. The petitioner is a holder of interstate permit on the interstate route Tata-Barabazar via Katin, Katin. Comma, issued by the State Transport Authority, Jharkhand. Stop. The said authority allowed the request for extension of the route up to Balarampur on prayer of the petitioner and by a letter issued on August 2019, requested the Secretary State Transport Authority West Bengal to consent, to give its consent to the said extension. Similar prayer for issuance of consent was made by the petitioner before the concerned authority on 13th August 2019. Stop. A similar prayer for issuance of consent and counter signature. The Secretary, State Transport Authority, West Bengal, in an order passed on 1st March 2021, recorded that the extension requested was not countersigned due to violation of clause 2 small h within bracket of the reciprocating transport agreement, 2004. And in a subsequent meeting held on 24th August 2021, the concerned authority
Fight agenda number
Sir.
22.
Yes,
Fight agenda number 22.
in a meeting. ওটা করুন, and in by and vide agenda number 22 in the subsequent meeting. যেটা held on বলো না তার আগে। Vide agenda number 22 in the subsequent meeting held on 24th August 2021, the concerned authority decided not to allow the counter signature to the said extension. Stop. Paragraph. Clause 2 small h of the reciprocal transport agreement dated May 27, 1988 is set out. Inverted comma open korun. Any extension / curtailment of a portion of an interstate route may be granted only by the permit issuing state as authority, subject to the consent of the reciprocating state if the portion under consideration lies in that state. Stop. But that extension or curtailment should be within the limit of 24 kilometers. Stop, inverted comma, closed, stop. The extension granted to the petitioner is admittedly within the limit of 24 kilometers.
Yes, ma'am. 18 kilometers, my lord.
18 is admittedly for, it is admittedly for 18 kilometers, comma, that is, comma, within the limit of 24 kilometers. Stop. There is no document on record. No, it is further admitted that no consent was taken by the concerned authority at Jharkhand from the West Bengal authority for prior to allowing such proposal for extension as required under clause 2 small h of the agreement. The petitioner has taken this court to agenda number 11 of the meeting held by the authority on 27th November 2020 and agenda number 14 of the same meeting, wherein the concerned authority has accorded has allowed extension of the interstate route to other operators, subject to condition that the length of the extended portion does not exceed 24 kilometers. Stop. The petitioner appears to be similarly circumstanced with the said operators whose extension has been favorably considered by the authority. Stop. Paragraph. The petitioner seeks to submit a fresh representation before the concerned authority in this regard. Include these documents in your representation and seeks a direction upon the authority to consider his representation favorably at the earliest. Paragraph. It is submitted on behalf of the respondents that the submitted on behalf of the
Second respondent.
second respondent that the second respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the second respondent within 7 days.
Within 7 days.
Within 7 days from date. Stop. The second respondent is directed to consider and dispose of the representation within 4 weeks.
6 weeks by STA board, my lord.
Within 6 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to the petitioner and upon taking into consideration the earlier decisions of the board of the authority, taken in the meeting held on 27th November 2020, as referred to above, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of a charge. You can take this one.
Deeply appreciated. Deeply appreciated.
It will be better if you can give a photocopy of this,
Yes.
this page, huh? Check for me. Yes.
107.
Pursuant to your lordship order,
Take the microphone, please.
but your lordship will kindly come to page 32. It's the order of the STA. The STA has taken the
Page
decision.
42.
Page 32. Blood, respondent number 7 has been plying his vehicle on the middle of the route, leaving the terminal point covered under the permit, against which an objection was raised before the authorities. Authorities took the decision in terms of the order passed by this court. That is page 32. Lord, your lordship, the last two paragraphs is relevant. Reports from the above mentioned RTOs were not available in this office for some time, and the delay leads to files Saidul Islam Mandal, another court case being number so and so. It's order dated 1/2003, the Honorable Court, High Court, Calcutta. All the RTOs concerned are directed to submit report to the Secretary STA, and he has been directed to consider and dispose of the said deputation, and the decision taken by the authorities shall be communicated to the petitioner. In the meantime, reports from the RTO concerned were received by this office, and all the RTOs concerned reported to the office that the vehicle bearing number operated by Onkar Shah, that is respondent number 7, does not complete the entire route, i.e. does not go to Palanpur. Upon receiving the reports from RTOs, a so-called notice was by number so and so was sent to Onkar Shah. After receiving the so-called notice from this office, Onkar Shah appeared before the Secretary STA. He admitted that he made a mistake and to not complete the entire route from Ghodbunder to Palanpur, and prayed for condone this mistake. He is also agreed to pay fine of rupees 35,000 as penalty for not completing the entire route. Onkar Shah has also sternly been warned not to violate permit condition and to complete the entire route from Ghodbunder to Palanpur. He also submitted an affidavit declaring that the said mistake as mentioned above, and payment of the said amount he also paid the same. In this way, the Honorable High Court's order has been complied with. Now, after this order being passed, again he has been plying his vehicle between the middle of the route, Ghodbunder and Bisnapur, leaving the terminal point, violating the order passed by the STA and the permit condition, for which another representation was made before the authorities, page 34. This objection was again raised, drawing attention of the authorities that he is still plying his vehicle from the middle of the route, violating the order passed by the STA concerned, and to take up and requested the authorities to take appropriate steps for execution of the said order, and to compel him to ply the vehicle on the permitted route under covered by the permit. In terms of the objection, the hearing was conducted on 13 May
11th May. 11th May.
11th May.
20.
But on that date, the respondent remained absent, for which the authority could not take the decision. And now I am paying for direction upon the state transfer authorities, being the respondent number 3, to take appropriate decision for the implementation of the said order, since he has been plying his vehicle from the middle of the route, violating the permit condition and the order of the STA. Page 32.
Page 39 too.
Page 39 is your.
Yes.
Page 39 is the.
Page 39 is
This will be considered, Mr.
Yes, page 39 is the
Private
order.
respondent, anything to add?
I have got this matter the earlier notice. So let it be considered by the authority.
Affidavit of service. Paragraph. Pursuant to an order passed by this court on 1st February 2023 in WPA 1127 of 2023, the Secretary, State Transport Authority, West Bengal, upon receiving reports from the respective RTOs and upon admission made by Omkar Shah, the
Respondent number 7.
seventh respondent hearing, recorded that the seventh respondent admittedly made a mistake in not completing the entire route from Gorbeta to Pahalanpur in terms of the permit issued in his favor. Stop. The said respondent agreed to pay fine of rupees 35,000 as penalty, along with penalty, and submitted an affidavit declaring the mistake. Stop. He was sternly warned not to violate permit conditions henceforth. Stop. Learned counsel for the petitioner submits that despite such direction / observation, the private respondent continued to ply his vehicle from Bishnupur to Arambagh.
Yes.
Bishnupur to Arambagh without touching the terminal points, in violation of the conditions of the permit issued in his favor. Stop. The petitioner submitted a further complaint before the concerned authority in this regard on 3rd April 2023, which is yet to be considered. Stop. Though a date of hearing of the said objection was fixed by the authority, the same could not be heard since the who did not appear, the
Private respondent remain absent.
the private respondent refrained from appearing before the authority on the said date. Stop. The petitioner seeks a direction upon the authority to consider the complaint filed by him at the earliest. Paragraph. It is submitted on behalf of the state respondents that who should be the authority?
Third respondent.
That the third respondent be directed to consider the representation in accordance with law. Complaint. In accordance with law. Learned counsel for the private respondent submits that he may be given an opportunity of hearing before the authority at the time of hearing. Paragraph. In view of the above, the writ petition is disposed of, directing the third respondent to consider and dispose of the objection submitted by the petitioner dated such and such within 4 weeks. Mr. Debra, second round.
Yes, madam.
Yes.
Secretary.
Within 4 weeks from the date of communication of the order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of which at length.
Deep Lordship.
Hearing. Hearing.
Group 7
Hearing
hearing,
matters.
item number 131.
151, 1090.
131.
Past 3:30, hearing matters.
My lord,
Hearing matter.
my lord, in 131, Mr. Shonajit Ghosh is appearing in this matter for the respondent
Yes.
railway. He's not well, he could not come today, he has prayed for not today.
Mr. Vasu, bad luck. First matter,
bad luck.
on prayer of the railways.
Railways.
On prayer of the railway authority, the matter is adjourned. Let the matter appear under the same heading on 27th of this month.
Grateful.
Monthly list. Adjourned. Monthly list. No.
Group 7 hearing from monthly list 1189.
1190 wala list.
1190. 1190.
So I am for the petitioner in this matter, my lord.
My lord, in 1190 also, Mr. Shonajit Ghosh is appearing for the railways.
Also, I am carrying the bad luck along with Mr. Only one thing, my lord, I will not going to press this matter. Only one thing, this matter is identical with another matter, Lordship has fixed it on 16th. This is the refund of punitive demand because 16th of this month. National Carrying Corporation versus India. Lordship, that has heard, Lordship directed me to effect service upon Mr. HON'BLE Sen appearing for the legal metrology in that matter. That we have done that in that matter. Lordship has fixed it on 16th. This is an identical matter. Here also there was an allegation of overloading on 16th. Pleadings are complete, ma'am.
Prayer of the railway authority, the matter is adjourned. Let the matter appear under the same heading on 16th June.
Grateful, grateful.
Item number 1191.
In this matter, I'm appearing on the private respondent number 3.
Petitioner,
Monthly list.
it was adjourned on the earlier occasion also.
Yes, yes, not accurate.
So let it be dismissed. None appears for the petitioner. No accommodation is sought. Dismissed for default.
Third word. Deeply. My evidence opposition can be kept on record.
Affidavit in opposition.
During opposition.
Shurute, affidavit in opposition
opposition.
submitted on, you are the private respondent.
Yes, private respondent 3.
Opposition submitted on behalf of the private respondent is taken on record. Upon none appears for the petitioner, no accommodation is sought. Dismissed for default.
On private respondent 4. Private respondent 4. Private respondent 4.
Private respondent 4. Yes, next.
Item number 1192.
1192.
92 to 30.
Yes, Mrs. Sinha.
Hello. This matter may be adjourned for a week.
Mr. Sinha is appearing.
My lord, I am not in proper uniform, so my lord.
Yes, requested me to.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 11th July. Hearing matters difficult.
1193.
9-3, my lord, I am for the petition.
Yes, 1193.
He is intervening, but
So it has to be adjourned. He is not in proper uniform today.
my lord, I am in this matter, I am in person, my lord.
You're in person.
My
Can achieve. Affidavits are complete.
affidavits are complete, but in the meantime, he served a
Intervention
application for intervention.
As a can.
That has to be disposed of.
Have you served?
Lord,
What is your prayer for
I have
addition?
not used any written objection to that.
So you have no objection to this?
No, I have not used any written objection, but in a hearing, I shall submit something which will.
So let him place his case first.
My lord. My lord, may I take your lordship to page number 9 of my application, my lord?
Now, both the parties wanted to use an affidavit in opposition to the application. Mr. Devra, the petitioner and the respondents wanted to.
He is the respondent.
The petitioner also wanted to file an affidavit in opposition. There's a recording on the earlier occasion.
Petitioner, I am for the petitioner.
You wanted to file an affidavit in opposition to the application. Where is
Lordship,
it?
but I could not prepare, and therefore
So
I.
will you come back with your affidavit on the next date?
Lordship, that may be.
Mr. Devra, you'll come back on the next date? Let them come back with the
My lordship,
opposition.
lordship.
Can 1 of 2022. Both the parties seek extension of time to submit the affidavit in opposition to the application as intended. Paragraph, let the matter appear under the same heading on 11th July, the same day.
11th July.
Next.
11th July.
Number 1194.
This matter, I'm preparing the petitioner. All our affidavit operation. My reply, everything is ready.
Yes. You have started your submission on the earlier occasion. Please continue. Yes. In fact, you have completed your submission, I find.
I have completed my submission, but after a long time to it. The shortcut matter, only shortcut.
Please take the microphone, Mr.
This one is our group channel. For the benefit of the by the distributor. Now, like challenge
This is at page? 23, yes. Yes.
Is bound by the provision. It has no general power. That power is like under Article 1 you cannot interfere.
And the permit number is also different in both the.
Now, my lord, by order debate, the first order. We should take must be
Oh, I was under the impression that Mr. Debra is appearing. Mr. Naik is appearing in this matter. You are ready, Mr. Naik? Yes. At page? Twenty-third September, yes, 2020.
Was made by the planning department to work with the project of the for the taxes. That's 27. Such application was by order. So, six months are explained. 5 was outside. What 21st October was my order was from the date. So my submission was right. Then without counter signature, last 20 was there, yes, must have been without counter signature. And was from without compliance, 102. 4 and 2. Scroll down. Before that, they come. If I log, there is same day. All the particles were so that. Yeah, correspondence. How is what capacity another thing? To enter back another aspect. Another aspect is application of law. So, our guidance set aside the difference. And where is this? This is absolutely wrong because according to the petitioner, what I might go for the extension document in respect of public number 160 or 62. He applied for 95.
What is your grievance against the private respondent?
Private respondent decision, according to petitioner, this party has been 500%.
Please.
Is good. Then they extend the control. This is good.
You've challenged the resolution in as far as your permit is concerned. So why the private respondent?
Private respondent I'm the head operator. I operate the permit. So the permit has without consideration because lost case. That is special. That is illegal. Now one existing operator has right to resolve. Again, the illegal. What's commercial? Illegal. Because that's why one settled by one system. That is why I'm simply
your objection was only on one ground, no counter signature. That has been obtained subsequently. So you have no grievance against the private respondent at the moment.
Well, this is to cover immediately at the time. Because if that I don't ask it from that that is commission to ask right on that also yeah. But mobile given all of this one also only from the competition of the ability all the parties
that since my lord, the vehicle flies 3 districts, cover 3 districts, counter signature is expected to be obtained from 3 RTOs. That was not done initial. That was the objection. Now, as a fine, my lord, the last occasion I have said, my lord, in the meantime, that has been completed, and my lord,
there is no grievance against the private respondent at the moment.
Yes.
The grievance is twofold. You have to respond to 2 grievances. One is how is the MLA
that's why, my lord, I say all the factual aspect and the way the points are being taken up, better it has to be resolved by, my lord, the authority in presence of both. That is the most That is the most reasonable solution. Otherwise, it is, my lord, obviously that would be done. Otherwise, how that would be done? My lord, I respectfully submit, my lord, this controversy can be, my lord, set at rest only upon hearing all the parties and, my lord, considering, my lord, when the signature was obtained. It is now done. Therefore, the main point goes. It has become infructuous. Be that as it may, being authority, we have no interest, no personal, my lord, interest for to be siding with anybody. So, my lord, this issue can again be, my lord, heard out, and, my lord, the papers can be looked into. Original signature can be verified in presence of both parties. Matter ends.
So what the MLA is concerned, my lord, this point was settled by the Supreme Court.
So
MLA, that is not an influential thing, my lord. No, that has got no, that has got no bearing.
not have been recorded at all.
On the basis of my lord,
This recording is illegal.
Lordship. So that is.
Can you set aside?
So, my lord, very well.
Subject to NOC from the local MLA or MP. What does this indicate?
But why my lord, respectfully submit, my lord, all these are for the public interest. Because the vehicle, how many vehicle will ply and where it will be posted? Here, my lord, no, that is in a very,
To decide that?
no, in a very peculiar circumstances that was done. So those who are public authorities, their recommendation opinion is needed to ply all these vehicles and to create the route,
Not
to
at
give
all. Please
permission.
show me the law.
It is not the only,
Provision, Mr. Nair.
but this is not the only criterion.
Please
So, my lord,
show me the provision where the recommendation of is necessary.
MLA, my lord, that cannot be, I cannot say.
Recommendation.
I cannot say, my lord, this is required under law. Kindly set aside and
Consideration.
my lord, and lordship kindly direct my lord to hear afresh and to take a fresh decision.
Mr. Mukherjee,
Lord, I am taking,
no role to play.
Lord, well, that is my contention, Lord. I am taking short leave, lordship. My junior is here. Kindly allow me, Lord, short leave, lordship, on content matter.
Mr. Mukherjee, what is your objection?
Objection is that the first hold objection is, my lord,
There is the contrary submission, because state, my lord, is in the opposition. He supplied the, my lord, he supplied the recommendation of the MLA. On the basis of that, permit has been issued. Route has been extended, and his affidavit, but he has not person to supply. That means according to him, the High Court has supplied the recommendations of the MLA. State has submitted in the reply on the basis of the supply, because he supplied on 26th September 2019. Then state private respondent affidavit. He has no function to supply. He has not supplied at all. Then the first affidavit.
Let us hear the private respondent. You want to come back some other day?
Yes, sir, it could take some time.
Very well. Let him come. Heard learned counsels for the petitioner and the state respondents. Paragraph on prayer of the private respondent. The matter is adjourned. Let the matter appear under the same heading on July 7.
I will be in travel, but I will not be here.
Very well, 11 July. Next.
Number 1195.
1195. Petitioner.
My lord, I'm only thing, just I'm praying that to close the exchange of affidavit opportunity, my lord, because 4 or 5 times opportunity has been granted.
You are appearing for?
My lord, I am the intervener. I have filed the recalled application.
You have not been added as yet.
No, my lord.
So no locus standi.
I have not been added, my lord. It is like it is like similar case as of Symphonil electric vehicle, in which your lordship has been pleased to dispose of the writ petition on the basis of 16-2 order of her ladyship, Mosumi
Who is
Bhattacharya.
appearing for the state?
My lord, one lady was appearing, but
Ms. Pandey, Ms. Adrika Pandey.
my lord, she has taken 3 or 4 opportunities, but no affidavit. Only waste of court's time.
Sir, I don't think you still have locus to move. Your
My lord, the
application has
similar,
not been allowed.
my lord, similar application was allowed by your lordship.
Maybe, but this application has not been allowed. So please wait for your turn. Let me fix another date. Will you intimate the state in the meantime? None appears for the state respondents. No affidavit in opposition is filed. Paragraph, let the matter appear under the same heading on 18th July. Paragraph, the petitioners are directed to serve notice upon the state respondents, intimating the adjourned date. Mr. Sinha is not in the picture at the moment. His application needs to be allowed.
Grateful.
Have you served copies to the others?
My lord, I have served. Grateful.
Next matter.
1197.
96. Disposed of. Disposed of.
My lord, I am not pressing this writ petition.
1197.
My lord.
Learned.
My lord,
counsel
as the
for
same is defective with the liberty to file afresh. It's having some defects, my lord.
Liberty to file afresh.
My lord, it's having some defects. I am not pressing the same, my lord.
Yes. Learned counsel for the petitioner seeks to withdraw the writ application and a writ application with liberty to file a fresh petition on the same cause of action. On the ground, seeks to withdraw the writ application of an ad for on the ground of certain defects detected therein. On the ground of certain defects detected therein, comma, with liberty to. Paragraph in view of the above, the writ petition being WPS as and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to file a fresh writ petition on the same cause of action. Paragraph, there shall however be no arrest costs as is certified to website.
Great.
client का service करो ना वो आज मेरा
Number 1198.
My lord, in this matter, my lord, this is the challenge to the TRI regulation. My lord, the Kerala High Court has passed a judgment deciding, my lord, the Vairis.
Digital Cable Federation, your lordship, your lordship, on 27th of February 2023, your lordship was pleased to direct to file affidavit in opposition in respect.
The matter has been decided.
Yes, my lord, kindly takes the order. My lord, they are the ones. Kindly takes this order. They are the ones who had challenged it. I'm grateful that my learned friend is also here now. Kindly sees the order, my lord. Detailed order given by Kerala High Court, my lord, the right at the top.
In this matter, I am for the all India added party.
They are the ones who challenged it before
Mr.
Kerala.
Kalyan Bandyopadhyay and Mr. Ratnamko Banerjee.
Yes.
They are the ones who challenged it before Kerala. Kerala High Court has decided it now. My lord, the Vairis has been, no, my lord, it's not been entertained, the challenge. Detailed order has been given. Petitioner, bhai, okhane de diye Kerala High Court.
Does anything further remain?
I am not the petitioner in this
My lord,
case.
they have, in fact, after this, my lord,
Although-
probably my learned friend has not been informed by his client. They have preferred an appeal before Kerala High Court. No stay. Appeal next is fixed in July.
In July?
Yes.
Who is appearing for the petitioner?
My lord, in Kerala.
Yeah, yeah.
My lord, here, the
Shah is appearing.
Mr. Jishnu Shah, who is my lord for the local cable operators, he was appearing. My
They are
lord.
the petitioners. in
Yes,
this
They are the
yes.
petitioner here.
matter. They have chosen to refrain.
My lord, after this, my lord, what remains? This was, my lord, the first place that initiated. This judgment was awaited. My lord, that your lordship was told. And now, my lord, the final judgment has also come.
Only one thing, your lordship kindly record that I have filed my opposition in respect of this.
Let there be another date, a very
Yes,
short
my
date.
lord. My lord, we'll also file our
They
opposition.
still do not appear. It will be
Very well, my lord. My lord, we'll also just file our opposition because that was your lordship's direction. No reply is also forthcoming, my lord, from the petitioners.
served.
Yes, my lord, it's
The
been served.
opposition copy.
Yes, yes, yes. Long back, my lord.
You are for respondent number?
My lord, I am for actually appearing for three parties. My lord, AIDFC, which is the my lord, IDBF, sorry, Indian Digital Broadcasting Federation, Star and Z.
And you are appearing for?
My lord, the added respondent, which is the All
The
India.
All India Digital Cable
I am
Federation.
appearing on behalf of the All India Digital Cable
So both of
Federation.
you are filing your oppositions.
Yes.
I have already submitted mine.
Affidavits in opposition filed on behalf of the All India Digital Cable Federation and for Star, ZZEE and IDBF. IDBF are taken on record. Paragraph, none appears for the petitioners. Paragraph, let the matter appear under the same heading. on 23rd of this month, next week.
Or my lord puts it with the monthly list of July, my lord. Otherwise, my lord, right now, my lord,
Because,
What is the use of dragging it further?
my lord, I don't know, my lord,
the
they
appeal is pending before the Honorable Kerala High Court on July for this reason. My learned senior friend.
my lord, they have preferred an appeal, there is.
Let the matter appear under the same heading in the monthly list of July 2022. Let it be
Grateful to you.
August then, not July.
July.
Monthly list of August.
August, okay, great.
Monthly list of August 2023. Huh?
And my lord, this order also, my lord, be kept with the record, my lord, I've handed over the.
যেখানে be kept taken on record বললাম ওখানে it's a judgment, isn't it? The
Yes, my lord,
judgment
it's the judgment.
passed by the Honorable High Court at Kerala.
Yes, ma'am. 4th April
Honorable High
2020.
Court of Kerala at Ernakulam.
And all people are appearing
On
for the
4th
petition in this
April
matter.
2023, submitted on behalf of the Star, Z and IDBF is taken on record. You are for the petitioner?
Yeah, I'm appealing for petition, my lord.
Yes, a judgment has been passed on the
A
same
judgment
issue.
of has been passed, my lord, but we have certain submissions to be made because, my lord, a judgment of a concurrent bench of another high court is not binding on this bench, my lord. We have those submissions when we have taken those points in a rejoinder. We'll file the
Judgment
rejoinder.
has been carried in appeal, I believe.
Yes, my
So
lord.
let this appear in the monthly list of August.
As your lordship pleases, my lord. In the
Let's
meantime,
see
my
what
lord,
the appellate court decides.
in the meantime, my lord, the time of filing of our rejoinder may be extended, my lord. We'll file it on the as the matter will come.
Non-appealable petitions say কেটে দিন taken on record হলো দুটো তারপরে non-appeals টা কেটে দিন learned counsel for the petitioners seeks extension of time to use a rejoinder / affidavit in reply to the affidavits in opposition filed by the respondents. Paragraph, let the matter appear under the same heading in the monthly list of August 2023.
Grateful to you.
The next item was হবে না? The part hard assigned matter is the next matter. My lord, kindly fix a date so that it's long pending since 2015, my lord.
My lord, I am appearing, my lord, as opposite party number 1, though 3, my lord. Though, my lord, I made an application, my lord, so that, my lord, I can appoint an independent advocate, because I was in that group of, my lord, other opposite parties. But I find that the other opposite party, without intimating anything, my lord, they are acting against the interest of the firm. That is the reason, my lord, I made an application. Though, my lord, I am not on merit, my lord, this is an only application that I want to move the matter independently, cancelling my earlier wakalatnama. Kindly allow me to appoint a new advocate.
7th. Well, in the month of January, when the matter was taken, there was an order passed by your lordship that if your lordship knows in this particular matter, the other advocates are rotationally absenting themselves. And lordship directed that in their absence, the matter would be heard. Well, that's true. But on that day also, I may serve another notice, but lordship kindly note they do not appear, the matter will be heard in that I have seen.
No, my lord, I am appearing. No notice is required. My lord, 7, the matter will appear in the supplementary list.
It will be.
Yes, I